Yes.
At 1 o'clock, would that be all right, Chairman?
Yes.
Yeah.
1 o'clock. 1 p.m. We got it. We're done. Okay.
Okay. I've seen it.
That's on the 25th.
Yes. They started the 25th at 1 p.m. And I've got BJ Burton and probably Doug Johnson lined up to testify that day. And then I'll
O'Donnell starts at 1.
yes.
You want to do this one in the morning then?
Well, I'll have
Following day.
the following day. I'll
I know
probably
he
have,
said the following day, but
I'll
I'm
probably
asking if he wants to do it in the morning on the 25th.
I'll probably have the lab examiner from Virginia to testify at 9 o'clock the next morning. I think
On
that's
the
when
26th.
yes. And that should conclude O'Donnell.
Well, I'll just tell you on the 25th.
Yeah.
We'll probably start at about 1:15 instead of 1.
That's fine.
Because it's Holy Week and they have services over here every day at lunch. That should be over by 1.
Okay. I might attend
Several
myself.
people want to go. Okay. Okay, thank you very much.
Judge, Miss Bell just came in, wanted to go.
Yeah, wait a second. Okay, Commonwealth versus Tiffany Bell. Are you Tiffany Bell?
Yes, sir.
Were you born in 1986?
Yes, sir.
Last 4 digits, social security number 0422.
Yes, sir.
We're here for sentencing in 23 CL 0074. You had an opportunity to look at the pre-sentence investigation report done by probation parole. Is it substantially correct? Counselor, is there any reason this lady should not be sentenced today?
No, Your Honor, the one thing I would say is in discussing, negotiating this case with the Commonwealth, we have actually did a referral for Miss Bell to go into specialty court in Clinton County.
On a plea of guilty possession of controlled substance, first degree. The defendant shall receive a sentence of 3 years, pretrial diversion for 5 years. Diversion is to be supervised, time for credit served. Is it an agreement for her to go into drug court in Clinton County?
This is the situation, if it's all right with the court, the Commonwealth have no objection. Miss Bell was oriented here in drug court in Cumberland County. After the orientation, she never showed back up. I had her assessed with Mr. Krause. Mr. Krause says she's got transportation issues. She could probably do it in Clinton County because that's where she's from. But
Did she abscond?
she just never appeared again. So if the court wants her to be sentenced and possibly file a motion for shock, she's eligible for Clinton drug court, or if you want to send her out. So whatever you want to do. Okay, that's where we are.
Well, I'm gonna let her go to Clinton County. But let me tell you something. Right now, on what you've done already, you could have your pretrial diversion revoke, be a convicted felon. This is serious stuff and that'll have an impact on your life. Do you understand what I'm saying? So this is your chance. And you're taking it. You've been given a big break today.
Sir.
Yeah, when can they orient her?
That'd be up to Mr.
Very drunk, already done that and expected me Friday.
But the only reason I'm considering this is because she never even got started in drug court. Basically, she was
The
here.
interview or vote her in or where she's at in the process?
She will have to be voted in Clinton County. She'd have to be oriented, so it's gonna take some time before she gets out of jail.
Well, I'll release her the morning that she's to be oriented.
Thank you, Judge.
Okay. What's your name, young lady?
Tyler Chambers.
Taylor Chambers, Commonwealth versus Taylor Chambers, 21 CR 00142. Are you Taylor Chambers?
Yes, sir.
Born in 2001,
Yes, sir.
last four digits, social security number 6405.
Yes, sir.
You're here for sentencing. If you had an opportunity to look at the pre-sentence investigation report,
Yes, sir.
is it substantially correct?
Yep.
One that you read, so you should be sentenced.
No, you're.
After a plea, you are sentenced to 5 years pretrial diverted for a period of 5 years with condition of release in Quick Cumberland County Drug. What are the court costs? Already paid. Oh, have you been, voted into the drug court yet?
Your Honor, if I could clarify, she was actually terminated from drug court and her pretrial diversion was voided. And so that's what she's here for sentencing for today. And so we'd like to be heard on probation if possible.
That's correct. Ms.
See,
Chambers was,
I had it wrong here.
she was in drug court and went to rehab, and then when she got back from rehab, I think she tested positive twice, was terminated. But I don't know, mischaracterizing.
Believe so.
Yes, sir.
That is correct, Your Honor. Your Honor, what we're asking today is as part of drug court, she attended 6 months of rehab. She did complete it. She stayed an additional 3 months and worked there. The PSI does not reflect any type of jail credit for that, but we would ask that she get jail credits. After she completed that rehab, she came back, began working at a nursing home in Metcalfe County. She's been there approximately a year, I believe. We have a letter here from that employer dated February 8th that they would like for her to return to work as soon as possible, that they are keeping her job for.
Give it to the Commonwealth. Commonwealth had the letter.
I'm not sure if I showed it to him last time or not. I will.
I'm just kind of off kilter on this thing because I looked at it and it said, didn't say anything. It's, if I see now, it says diversion voided on 2/29/2024.
That's correct. We had it here. I think we had it here, or y'all stipulated. I
We
think
stipulated.
Stipulated, and
What do you have to say about this?
I think because she was in drug court so long and she was terminated, I think I'd look very favorably on a shock motion show she could go back and work, but I hate to just turn her loose on this. Now, I understand where you're coming from, where Mr. Poindexter's coming from, but, the problem was she participated in drug court a long time and then continued to use even after she was out of rehab. That was the problem she had. And that's the part that still, I know she's got this job and she looks well, but she still got to understand she's got to get used to. You
Well,
understand?
right, and I appreciate the offer on the shock. I would say that she's already spent 30 days in jail.
Yeah.
And that she has housing at Oakland Heights, that I'm afraid that she may lose it if she's continues.
Well, I mean, this is stuff that's just brought up right now.
Yes, sir.
Do you know anything about the case? I mean,
Well,
you can't
what
just
I've
wait
heard
to
say-
get here.
Yeah.
You know, anybody's terminated from drug court and they have reasons. You know, we usually just go ahead and sentence them and maybe shock them out.
And I know they're probably wondering about the previous case, but that girl never even got started in drug court. It's the difference. And Ms. Chambers was in drug court for quite some time.
I'm kind of wondering about the previous case too.
I may have made a mistake.
I don't
Try to be
know.
consistent, but I sometimes I'm
Well, you
not.
don't think about it until you get another one.
Yeah.
You know what I mean? And
Yeah.
What about doing home incarceration? So that way she can return to work.
Well, our rule day is early this month. So by the rule day in April, she will be eligible for shock probation.
Yes, sir.
So I will, seeing what the Commonwealth has to say about this, I will look favorably on shock probation. So I'm gonna go ahead and censure, make her a state prisoner today. And then we'll be here on, April the 25th. In between now and then, we'll need to work on to see how many days credit probation and parole. You need to get in contact with them to see how many days credit you think she's entitled to.
Yes, sir.
Okay.
Will the court give her credit for the rehab that she did?
I want to see what she has. I don't know whether I will or not. I want to know what kind of place it was and how, that sort of thing. Sometimes we don't do it, sometimes we don't.
Yes, sir.
We'll take a look at it. She shouldn't be worried about the credit if she's not gonna get any more problems.
Right.
Gonna behave.
The PSI shows 167
Probation,
days.
we'll see you back and you can talk to Commonwealth and see what their position is on rehab. I mean, there are rehabs and there are rehabs.
Yes, sir.
So you need to come to talk about what kind of place she was in. I mean, some of these places, there are more drugs available there than there on the street.
Yes,
They
sir.
just run along. Okay, thank you. Yes. Now, do we have the other transported prisoners here? Let's go ahead and get them. Taylor Chambers. We already did Taylor. We just did Taylor. Joshua Duvall's who I meant to call. He's finished with one. Oh, he is Kenny Huddleston. We didn't do Jason Bauer. Yeah, that's what got me honest. Kenny Huddleston, and then Kenny Huddleston, and then Jason Bowers is next. Commonwealth versus Kenny Huddleston, 23 CR 00113. Are you Kenny Huddleston? You're on 23 CR 00113. Were you born in 1990?
Sir.
Last four digits, social security number 9589.
Sir.
Okay, we're here today for sentencing. If you had an opportunity to look at the precinct's investigation report done on probation and parole,
Yeah.
is it substantially correct?
Yeah.
Counselor, is there any reason this gentleman shouldn't be sentenced today?
No, Your Honor.
Well, plead guilty to fleeing invading police. First degree, he should receive a sentence to 1 year, probated for 3 years. Probation to be supervised. Agrees to enroll and complete the Cumberland County Specialty Court. Court costs and how much? $215. I'll let you pay that at $30 a month. First payment being due 30 days from today, okay? She gained employment. All paraphernalia, contraband should be destroyed. Remain active until all fines and court costs are paid or until further request of probation. Now, has he been interviewed by the specialty court?
He has been interviewed, Judge. I think he'll either be voted in this Thursday or next Thursday.
Okay, well, I will let you out of jail if you get voted in on the day you get ordered. Okay.
Thank you, Judge.
Thank you very much. Okay, Jason Bowers. Jason Bowers. Commonwealth versus Jason Bowers, 22 CR 00082. Are you Jason Bowers?
Yes, sir.
You born in 1984.
Yes, sir.
Last four digits, social security number 7956.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report under probation and parole?
Yes, sir.
You had a pretrial diversion. It was voided on February 29th, 2024.
And Judge, this is one where the Commonwealth has agreed to refer Mr. Bowers into Cumberland Specialty Court. He's already been referred. He's had his assessment. Mr. Huddleston, he's still awaiting.
Commonwealth, tell me something.
Well, I would agree to refer him to drug court along with some mental health treatment. I don't know if he's signed up for that because that was part of the diversion when he was revoked for mental health treatment. This is the case where he's a veteran. He's got, looks like he's had problems and he had a gun. He had that. He was, I don't know if he was discharged the firearm or not, but he had been accused of it. They found the gun and some shells. He wasn't a convicted felon. He was convicted of wanton endangerment, got a 5-year sentence. Only criminal history he's got, looks like, is a DUI and a previous terroristic threat.
Judge,
But then I got to reading the PSI and it's saying that the officers had had problems with it before. I wasn't aware of that until I read the PSI.
Judge, Mr. Bauer is, or before incarcerated, wasn't went through mental health treatment. Just to remind the court, he's also the individual that currently enrolled in online courses, which is doing well. Judge, I think the Commonwealth kind of spoke to some of the underlying mental illness going on here, so that's part of the reason we're asking for.
I don't know, Mr. Stockton.
Yeah,
It's a dangerous situation here.
and I don't know that the drug court will take him because of the mental health issues. That's another issue, even if he said. So.
And Judge, given that last statement by Mr. Stockton, I would have no objection to passing. Waiting to see if we.
I'm gonna go ahead. I can go ahead and sentence him and take a look at shock probation. His pretrial diversion was voided. It's the pre-sentence investigation report. The next logical step is I have to sentence him. So I'm gonna go ahead and sentence him to 5 years. And then, between now and then, we'll see if they'll take him. I'm concerned about this officer's statement. Have the officers been consulted with on this?
They were at the plea, they were all right with the plea
Well, I guess they were.
at that time. They hadn't been consulted since then.
And Judge, I'll just speak, it was, the case, I wasn't involved in the underlying case, but I think the resolution that being pretrial diverted speaks to whatever wishes the officer would have had at that time.
Mr. Stockton said they were in agreement with it at the time.
Yeah,
But there's this individual here. And I really don't know you, sir. I don't have anything against you or anything. But some of this shooting with a semi-automatic weapon out in the community over there, and it's a wonder they didn't kill you. So one of the officers who responded didn't kill you. Happens all the time. And so, how long were you in the military?
4 years.
Yeah. Well, I'm gonna give that some consideration too when we start, but I think somebody needs to contact maybe the VA or some other people, see if there's any kind of,
And I think I don't know about VA, but again, I know, I will echo Mr. Bauer was going through significant.
well, I
mental treatment
understand that.
Out of custody.
I'm not criticizing him. I'm just wanting to protect the public and him too. You get out in the front yard shooting an automatic weapon every direction. These police officers come, and they tell you to show your hands, you run back in the house, that sort of stuff. I'm just glad for them and for you. And for people that care for you. So we'll take a look to see what the appropriate situation is to protect the public and try to get you some help too. But we'll do it. I'll send you the 5 years, and if you'll find a motion for shock probation. And then between now and then, if you work with the Commonwealth to see what's available. I don't know what the VA has available, but somebody needs to talk to the VA and see what they have available, to see if this gentleman has any kind of. But did you get an honorable discharge or?
Yes, sir.
Okay. There you go. They got all kinds of services that aren't available, as they should have services that aren't available for people who have served. Okay. See you next month. Thank you.
So I'll go.
Do that. Kenneth Neil. Commonwealth versus Kenneth Neil. For sentencing. Commonwealth versus Kenneth Neil. 23 CR 0025. Are you Kenneth Neil?
I am.
You born in 1978, sir?
I was.
And the last four digits of your social security number 4427.
It is.
Okay, have you had an opportunity to look at the pre-sentence investigation report done by probation?
Yes, sir.
Is it substantially correct?
It is, Your Honor.
Okay, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Okay, upon plea of guilty possession of controlled substance first degree, the defendant shall receive a sentence of 1.5 years to serve. The Commonwealth will oppose probation. However, this sentence shall run concurrently with Wayne Circuit Court 23 CR 00153. The court costs in the case are
$210.
$210. I'll give you some time to pay that. I'll,
Go ahead, give me a little while.
do what?
Guys, give me a little while.
Oh, I'm gonna give you a bunch of time, yeah. Is just got the 1.5 years over there and,
No, Judge, I think he's facing.
6.
well, I'm gonna waive the court costs.
Thank you, Judge.
No reason to. You plead guilty and you're taking significant time, I'll waive the court costs, okay?
Thank you.
Okay. Hey, thank you very much.
What's your step?
John Scott. John Scott. Commonwealth versus John Scott, 23 CR 0045. Are you John Scott, sir?
That's it.
Okay, we're here on 23 CR 45. Were you born in 1962, Mr. Scott? And the last four digits of your social security number, sir, are set 9063.
Yes, sir.
Okay, we're here today for sentencing. You had an opportunity to look at pre-sentence investigation report. Then the probation, well, is it substantially correct? Anything incorrect?
Yes, sir.
Okay. Counselor, is any reason this gentleman should not be sentenced today?
No, Your Honor.
You were previously pretrial diverted and that was voided on February 29th of this year, so I'll sentence you to 3 years to serve. And does he have any other cases anywhere else? This is it?
Judge, I think he is, there was a Tennessee case, but I think he has finished
care
that
of
case and taken care of it. So.
Okay, well, okay, thank you very much. Ethan Wilson. Commonwealth versus Ethan Wilson. Are you Wilson?
Yes, sir.
You born in 2002?
Yes, sir.
Last four digits, social security number 7254.
Yes, sir.
Okay, you're here today for sentencing and you had an opportunity to look at the pre-sentence investigation report.
Yes, sir.
Is it substantially correct? Is there anything you want to change?
No.
Okay. Your pretrial diversion was voided on February 29th, 2024. Therefore, we'll sentence you to 3 years with a credit for time served. Okay? Thank you very much.
And Judge, I know you just sentenced Mr. Wilson. In lieu of sentencing this man to prison, we would ask for rehab. I know he's in specialty court before, but
Well, I'll take a look at shock probation. For the comment. Sure. Gotcha. You know what I mean? Okay, let's go back to,
I think we still have one transported preachers out here.
we had Joshua Duvall.
He's in 600.
Oh, okay. Yeah,
So I passed over him.
Yeah.
Jennifer Fairley. Jennifer, do you say your name Fairley or Farley?
Fairly.
Fairley. Well, people do it both ways, you know. Okay. We're here on 23 CR 00112. Were you born in 1972, ma'am?
Yep.
Last four digits, social security number 8599.
Yeah.
Okay. We're here on a pretrial conference.
Are we ready to set this for trial?
Well, remember, I need to get this information from my client about the medical records and get that to you. I've got that from her, so I really don't think so.
Well, let's do one more negotiation day if we can't resolve it. Let's set
When
it
is your
right.
negotiation date?
It's April the 5th at 9 here in Perkins.
April the 5th at 9 a.m. here, and your next court date is April the 25th. Both of them are conditions of your bond. You'll be here for that negotiation day. And you'll be here on April 25th, and we don't have a resolution. We'll set you a speedy trial, okay? Chad Faulkner.
Your Honor, on another note, I've been advised Ms. Perkins on the way to court. I know you called her while I was in the back. We'll do the recommendations. It was.
Well, we'll be ready for her when she gets here too. Chad Faulkner. Commonwealth versus Chad Faulkner. 24 CR 00011. You are Chad Faulkner, is that correct?
Yes, sir.
She born in 1983.
Yes, sir.
Last four digits, social security number 7024. Who's your attorney?
I don't have one. I got this letter from him and he's, well, fired him.
He was first supposed to be the district court, and then he hired private counsel, who's now a motion in the court to withdraw.
Who was your private counsel?
His name, or D Hart from,
Matt Hart changed him. Sure, he has a motion on the name.
Has Mr. Faulkner been arraigned? Okay, I'm gonna ask public advocate to step in for arraignment. It's the indictment in here. The grand jury, you have a right to remain silent, Mr. Faulkner. The grand jury of Cumberland County is returned to the indictment, charging you with possession of controlled substance, operating under the influence, possession of marijuana, disorderly conduct, failure to maintain insurance, proper display of registration plates, no registration plate receipt, careless driving. Counselor, you acknowledge the identity of Mr. Faulkner, receiving that waive formal reading and arraignment, enter plea of not guilty.
I do, Your Honor, with one caveat, if I may. I know before Mr. Faulkner had DPA appointed, my partner, Miss Juliana, conducted the preliminary hearing before private counsel showed up. So I just want to see if he,
The only reason I'm appointing you is for arraignment.
okay,
I'll have to make a determination later if he's eligible. And I'm gonna ask him to go with pretrial folks and fill out an affidavit to see if he's eligible for appointment. If he's appointment, then of course, the Department of Public Advocacy can assign whoever they want to the case, previous counsel or you, whatever. See what I'm saying? It's not.
no, I understand, Judge. I just wanted
I
to,
understand. Now, also, Mr. Faulkner's surety, Shirley Faulkner has requested to go off the bond. So I will approve that. He's in the custody of the jailer until he can make another bond. Now, you might want to go here and be interviewed.
yeah,
Be interviewed by the pretrial, see if you're eligible for it.
Yes, Your Honor, and if the Commonwealth would like to address the bond conditions if there is another bond set.
Okay,
I would ask that he have an ankle monitor and if he's released, because according to the reports I'm getting, he's not following his home incarceration guidelines and been violating.
I'll order an ankle monitor as an additional condition. What? Make sure.
I'll write that down. Yes, sir.
Do what? Yeah. Okay, tell the sheriff that he's to get ankle monitors, probably his new bond condition. Something. Okay, Kelsey Jones. Kelsey Jones. Randy. Commonwealth versus Kelsey Jones, 24 CR 0003. Are you Kelsey Jones?
Yes, Your Honor.
Were you born in 2001?
Yes.
Last 4 digits, social security number 7057. You're represented by Mr. Poindexter. We're right to remain silent. I don't see how they did that, but in there. Okay, pretrial conference. You would? What does the Commonwealth have to say? You had negotiation on
We
this?
did, the
Could you
incest
speak up
indictment,
just a
the
little?
incest indictment was improper because this was an act occurred with
You
a,
need to speak up a little bit.
the incest indictment in this case was not valid because this sexual act occurred between her and a stepsister. So the incest indictment did not apply. I have spoken with the victim's mother and we've worked out a plea if the court will approve as regards an unlawful transaction with a minor.
Okay, what is,
The offer would be 5 years on unlawful transaction with a minor, serve 30 days in jail, the balance pretrial diverted for 5 years. She's to enroll and complete the sex offender treatment program as outpatient, maintain gainful employment, pay court costs at discretion of the court.
y'all got,
We do, Your Honor.
And there'll be a likewise plea for the co-defendant. The only difference will
okay,
be,
what? This is a felony plea?
yes, but it's a diversion.
Do what?
It's a diversion. right?
Diversion.
Yes.
Motion has been tendered, Jones, that says that you wish to enter a plea today. Is that correct? You have to speak up.
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person previously named in 24 CR 003?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you believe you've been fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
You have a right not to testify against yourself. No one can. The same thing, right to speak in a jury, the right to be represented by counsel at your jury trial.
Yes, sir.
The right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to apply the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering the guilty plea today, you give up those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I don't have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial.
Yes, sir.
I've got some qualifying questions I need to ask you. Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the last 10 years?
No, sir.
Are you currently on probation?
No, sir.
Do you understand that if you complete the diversion agreement, the charges will be dismissed, pretrial diverted, you can have your record expunged. However, if you don't successfully complete the program, you're brought back in front of me and I void your pretrial diversion. I'll order a pre-sentence investigation report. You get sentenced, convicted felon, any future convictions in the future can be enhanced. Do you understand that?
Yes, sir.
What is the Commonwealth's recommendation in this case?
Your Honor, Ms. Jones will plead guilty to unlawful transaction with a minor, second degree, receive a sentence of serve 30 days, balance pretrial the verdict for 5 years, diversions be supervised. Will complete the sex offender treatment programs as outpatient, maintain gainful employment or do 30 hours community service a week and pay court costs at discretion of the court.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the act charged in the indictment?
Yes, sir.
Okay. Are you doing so of your own free will?
Yes, sir.
How old was the victim?
She's 14. She's Miss Jones's stepsister. And I've had lengthy discussions with the child's mother. This happened and the child didn't disclose. The mother became suspicious. She was found out sort of through their cell phone that this happened.
Who was told him?
Be Miss Jones's husband, her significant brother, Michael Riley.
And was he involved in this too?
He was, these, I don't know if they're married or live together. All three were involved, this one incident.
You know your constitutional rights to explain to you, is it still your desire to give up these rights or plead guilty and allow the court to fix your punishment?
Yes, sir.
Is that your signature on the document?
Yes, sir.
Well, I will accept the agreement because I've been assured that the victim and the parent are in accord with this. What was her time to serve?
30 days. She has some time in, I don't know if she's got her 30 days served or not. The other folks, I don't think there's any time.
Okay. Well, you'll need to meet the probation and parole officer, but you're in the custody of the jail. Court costs $185. When you get out of jail, you can start paying that at $30 a month, 30 days after you get out. In custody of the jail. If you'll hand it up, I'll sign it. If you'll hand it up, I'll sign it. Jerry McClister. Jerry McClister. Jerry McClister. Did you fill out to this? I signed for it. Jerry, are you Jerry McClister?
Yeah.
This is 23 CR 0077. It says you're represented by the Office of Public Advocacy.
Judge, I think this was, Mr. McClister, I was saying motion for hardship license. But I don't care to stand in for it.
Okay.
He's just asking available to second policies.
You have an objection to driving his alcohol classes.
As long as he's qualified.
Where are your classes?
Come here.
Okay. Well, you're not to be driving anywhere but here, directly up there and back. Okay, I'll sign. Pick a copy up this afternoon.
Thank you, Judge.
Charles McCoy. Says 22 CR 00044, a status hearing.
I guess I'll just ask for a warrant to bring him in front of the court. We've had him the last 2 times he's not been present.
Judge, it's my understanding he has got a neighbor that can transport him. However, he works out of town with A&Z Communication. It would be Todd Spears. He reported to my office this morning that he's taking his medicine and seems to be in good shape. Mr. Spears, his kind of caretaker right now.
I really don't want to arrest him and send him back to jail. It's a nightmare. He was like a year or something last time we sent him up there.
And Your Honor, his health suffered greatly while he was in jail the last time.
I'm not gonna send him back to jail this time. But he needs to be here next time. You know, if somebody wants me to get a civil summons or arrest warrant that morning, go down and get him and bring him up here, I'll do that. But I need some assurances he's gonna be here. If he's not here, I want the sheriff's department to be ready to go down there and get him that day. It might be the best thing to issue an arrest warrant for him that morning, so y'all can go down and try to round him up, get an eye on him there. Okay? So as it comes, if the time comes closer, we'll do a summons to get him here on that date. And if it's sheriff, if it doesn't appear that he's gonna be cooperative and be here, you just tell me and I'll sign a warrant for you, okay? And you pick him up that morning. I don't want to transport him yet.
I can be in contact with Mr. Williams and see if his caretakers are agreeable to bringing him up that day.
You know, the sheriff, you mean?
Or no, Mr. Spears, the guy.
You
that's
said
been
you were
taking
gonna
care
be in
of
contact with the sheriff about
it.
it?
Yeah, I can be, if
Okay.
that's okay.
We'll just keep the sheriff informed.
Okay.
Thank you. John Metz. Active warrant.
We'll have to bring NCIC down.
Brian Muse. Brian Muse.
Judge is actually here. Stepped down, he's represented by Mr. Mr. Muse just caught me coming in and asked if I was representing him today, and if I was coming for Mr. Garrett, it's on 9:30. You called Mr. Garrett?
Yeah, he's one point about that.
You what?
Come up here, take his camera.
Commonwealth versus Ken Muse, 23 CR 0037 yard Ken Muse. Brian Muse at me. You born in 1980. The last four digits of social security number 9937. You're represented by Mr. Ken Garrett. He's not here today.
He was on the phone, he said he was calling Jesse, Jesse here.
Mr. Garrett been in contact with you, Mr. Stockton?
No, he has not. Not on this case, I don't think.
What did Mr.
We're up for sentence and I'm just wondering why he's switching models here.
I think, Lord,
Well, yeah, Mr. Garrett is representing him on this. He should be here.
I think it was a schedule, I don't know what his
Okay.
schedule was. He said he was gonna give him a call, just bought it.
But I hadn't heard from Mr. Garrett before this morning. Wait, did you talk to
I
Mr.
just
Garrett?
talked to him out hall, he said he's gonna call her back.
Okay.
Have you looked at the precinct's investigation report? She was showing you that.
Yes, sir.
Just see, we gotta see if you can call Mr. Garrett. Oh, we got to show you.
Yes. Okay.
Let me put you on speakerphone. Mr. Garrett said he put him on the wrong date. He's wondering if he can do it by Zoom.
Send Mr. Garrett a Zoom invite. Watch for your phone, Mr. Garrett, for a Zoom. invite. Okay, come back to me.
Thank you.
Which means you just sit back there and when your attorney gets on Zoom, you'll probably back. Natalie Owens.
She's not been served either, Your Honor. We'll put her in NCIC. I have one question on Mr. Faulkner, so he can be released. Is he gonna have DPA appointed for the entire case or just the rate?
Yes,
The entire
I
case?
just signed an order. He is eligible.
Okay, well, that's for the negotiation day, April the 5th and that.
April 5th and 9th for Mr. Faulkner. 9 a.m. April 5th here, Mr. Faulkner, and the next court date is the
25th.
25th. 9 a.m. on April 5th and then 9 a.m. on the April 23rd. William Owsley. Are you William Owsley?
Yes, sir.
You were born in 1993?
Yes, sir.
Last four digits, social security number 4996. We're on 24CR 00010. For arraignment, you're represented by counsel. You have the right to remain silent. Anything you don't understand, you step away and talk quietly to your attorney if you have any questions. The grand jury of Cumberland County is returning an indictment charging you with possession of controlled substance in the first degree, possession of drug paraphernalia, expired license plates, and speed. You understand those charges? Set the reciprocal discovery. Now, I'm gonna sign a reciprocal discovery order. Requires the Commonwealth to give y'all information. Counselor, you acknowledge the identity of the client received indictment, await formal reading, and interpleading not guilty for all pre-trial motions.
Yes, Your Honor.
Okay, if you'll be here at 9 a.m. on April the 5th for negotiation. And then on April the 25th at 9 a.m. for your next court appearance, both of those are conditions in your bond, okay? Charles Perkins. Charles Perkins. Commonwealth versus Charles Perkins. 23CR 00110. Are you Charles Perkins?
Yes, sir.
Born in 1981.
Yes.
Last four digits, social security number 9080.
Yes, sir.
You're here for a pre-trial conference. What's the Commonwealth have to say?
We have a felony plea, I think, Your Honor.
It's correct, Judge.
Sir, I've just been informed that a motion has been tendered, says you wish to enter plea today. Is that correct?
Yes.
Are you currently on the influence of drugs or alcohol?
Sir.
Is this plea freely and voluntarily entered?
Yes.
Are you the same person we just identified for the record in 23CR 00110?
Yes.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Is your mind impaired today in any way? You have to say something. It's voice activated microphone.
Speak up.
Okay. Have you reviewed the evidence Commonwealth has against you? Believe you're fully informed about your case?
Yes.
Okay, you understand you have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you understand those rights. You have a right to remain silent. You have a right to an attorney. You have a right to speedy trial. You have a right to confront and cross-examine all witnesses, call testify against your right to produce evidence, right to call witnesses in your favor, have process issues, compel their attendance. You have a right to appeal this matter to a higher court. You lose your right to require the Commonwealth to prove your guilt beyond a reasonable doubt. You understand that by any of the witnesses, you give up those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply it in since private law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll wait the pre-sentence investigation report. And in the event that I do not accept the recommendation and decide to impose a harsher sentence than you agree to, you'll have a right to withdraw your plea, proceed to trial. You understand that?
Yes.
What is the Commonwealth's recommendation?
Your Honor, Mr. Perkins will plead guilty to flagrant non-support, receive a sentence of 5 years, probated for 5 years, probation be supervised. He'll make monthly payments at the rate of $180.93 plus $100 on arrearages a month for a total of $280.93. Said payments are be made to the Cumberland County Division of Child Support Enforcement with the appropriate 4D number. First payment is to be paid on it before April the 1st, 2024, and the first day of each month thereafter. Once the oldest child turns 18 years of age or graduates high school, whichever comes first, arrearages shall increase to $250 a month. Probation will continue until the arrearage is paid in full. This matter may be reviewed every 12 months. He's to maintain gainful employment and pay court costs at the discretion of the court.
I'd like to review it every 6 months. Okay?
That's fine.
Is that what you agreed to?
Yes.
Are you entering this plea because you are guilty of the charges in the indictment as amended?
Yes.
You're doing so of your own free will and knowing your constitutional rights. Is that right?
Yes.
Okay, now you understand after an entry of a plea of guilty and this charge, if you have any other felonies in the future, it could be enhanced. Now, there are some provisions that are being passed these days about getting felonies expunged like this at a period of time. That's right, Counselor?
It is, Judge.
So you got the possibility, but you'll stay on probation here until all of this is paid and the court costs are paid. What are the court costs?
$185.
$185. Since you have a significant child support payment, I'll let you pay $185, an additional $20 a month, okay? And that first payment's due 30 days. So that's your signature on the doc.
Yes, sir.
I'll accept the plea. You'll need to meet with the probation parole officer today.
Thank you, Judge.
You what? Yeah. See what? Yeah, it wasn't a diversion. We'll have, he'll have to come back for sentencing on April the 25th. Since Michael Riley. Commonwealth versus Michael Riley. 24 CR 0004. You Michael Riley.
Yes, Your Honor.
Born in 2000.
Yes, Your Honor.
Last 4 digits, social security number 6104.
Yes, Your Honor.
Okay, we're here on a pretrial conference. And is this a companion case to the other case?
Yes, Your Honor.
I understand that you wish to enter a plea today.
Yes, Your Honor.
And is this a felony plea also?
Yes, sir.
A motion's been tendered, sir, says you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Are you? He said it was a felony plea.
Well, it's felony pretrial diversion. I'm sorry, Your Honor.
Are you the same person named in indictment number 24 CR 004?
Yes, Your Honor.
Are you had plenty of time to talk to your attorney and are you satisfied with his advice?
Yes, Your Honor.
You agree with the evidence the Commonwealth has against you, believe you're fully informed about your case.
Yes, Your Honor.
You understand that you do not have to enter a guilty plea today. You have certain rights in Kentucky and the United States Constitution. Before I accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, the jury, right to be represented by counsel at your jury trial, the right to confront, cross-examine all witnesses, call, testify against you. The right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, Your Honor.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. However, if I decide not to accept the recommendation after your plea and desire to sentence you to a harsher term, you have a right to withdraw your plea and go to trial. I've got some qualifying questions I need to ask you. Have you previously been diverted in the last 5 years?
No, Your Honor.
Have you had any felonies in the last 10 years?
No, Your Honor.
Are you currently on probation?
No, Your Honor.
You understand that if you fully complete the diversion program, the charges will be dismissed pre-trial diverted. However, if you fail to complete the diversion program, you'll be brought back before the court and sentenced after having a pre-sentence investigation. Then you'll be a convicted felon. This can be used against you in the future as enhanced penalties. Do you understand that?
Yes, Your Honor.
Mr. Stockton, what is the Commonwealth's recommendation?
This is the companion case, the one we did a while ago, Your Honor. He would plead guilty to unlawful transaction of a minor second degree, receive a sentence of 5 years, serve 30 days. If approved of the court, that could be done on the weekends. He has a job at Tyson's he wants to keep. He agrees to enroll and complete the sex offender treatment program as an outpatient, obtain and maintain gainful employment, and pay court costs at discretion of the court.
Is that what you agreed to?
Yes, Your Honor.
Are you pleading guilty to this because you are guilty of the acts charged in the indictment as amended?
Yes, Your Honor.
You know your constitutional rights that explains it's still your desire to give up these rights and enter a plea of guilty to the charges and allow the court to fix your punishment when committed by law.
Yes, Your Honor.
Set your signature on the document there.
Yes, Your Honor.
And the victims are in agreement with this, in this case, like they were in the other case.
Yes, Your Honor.
Where will the sex offender training take place?
I'd have to defer to Mr. John on that.
Your Honor, I'd have to, we have a sex offender officer that handles all the sex offender cases. And I'll have to get with him on getting them linked up. Once he reports to me for intake, I will put him in direct line with, Officer Brian Hogan.
That included staying away from the victim, correct?
Yes.
Okay, we need to meet with the probation parole officer. What are your working hours at Tyson's?
Monday through Friday, sometimes Sunday if they need me. Whether they do a draft system, so if they don't have enough people, then
What hours on Monday through Friday?
from 2:25 to anywhere between 9:30 and 10:30, depending on if USDA comes out and checks us.
You know, I was just talking to him. He may already, if you gave him jail credit for home incarceration, he may already have 30 days served.
I don't think that'll work for Fletcher.
Okay.
Do what?
That will not work with the big, she wants 30 days jail.
Okay.
At
I'm
least,
not gonna give credit.
yeah.
Okay.
I was just wondering where you could serve. You can't hardly serve in Adair County. Go over there. Does Cumberland County ever do a deal with Clinton County to house anybody over there?
We have before.
Well, I know where he lives. But he's gonna be working in Clinton County, getting out in the middle of the night. And it's a little easier to get in and out of the Clinton County jail than it is Adair County.
I would suggest Mr. Poindexter doing an order that he could serve it in Clinton County Jail, and if the Cumberland County and Clinton County reach an agreement, that's fine. If not, he can pay the jail fees. But he's gonna have to pay the booking fee anyway. That's another added cost to him doing this 15 times instead of getting it over at one time.
I'll create an order.
Yes, sir.
Are you scheduled to work today?
Yes, Your Honor.
I would just let him report Friday when he gets off work. Served in the 48 hours. Let me be released.
Thomas J., will you give him your phone number? And he can call you. You'll know where they worked out a deal with Clinton County.
Yeah, I can call her. I can call
You
her.
give him the phone number and he'll tell you where to report after you get off on work on Friday, probably Clinton County Jail. And this Sunday thing that you got, I don't think you'll be working on Sundays, okay? Okay, thank you very much. 185, you pay that $30 a month, first payment, 30 days from today.
Won't make this call or Jay on there and see if they.
Well, can you reach an agreement with them or does it have to go through the county judge's office?
That's not for sure.
We'll just check around.
Okay.
Okay. You get his number, go over there and give it to him.
Okay.
Right now. Okay. Nicholas Ray. Commonwealth versus Nicholas Ray, 24 CR 0002. Are you Nicholas Ray?
Yes, sir.
You born in 1999?
Yes, sir.
Last four digits, social security number 1919.
Yes, sir.
We're on 24 CR 002 for a pretrial conference. What do we have here?
Your Honor, Mr. Ray had another possession case. He was placed in the specialty court program. He's doing well and he'll probably graduate, no problem. I don't want to jinx him, but he's doing well. This case occurred at or about the same time. He wasn't indicted. I'm just trying to clean up the docket. I'd ask that we just continue this generally and I'll dismiss it once he graduates from the drug court. It's another possession case.
Since we don't know for sure when you're going to graduate from drug court, we'll continue generally to be redocketed. If you have a violation of some sort or the Commonwealth has a reason to redocket, so continue to work hard in drug court, okay?
Thank you, Judge.
Let's go to the Barron County Detention Center. We have Bell County Forestry on there. Bell County, are you on there?
Yes, sir.
Let's go ahead and do Bell County since we just have one, and then we'll go right to Barron County. Bell County, turn your camera on, please. This is Commonwealth versus Michael Carroll. Get his file. 24 CR 001 Are you Michael Carroll?
Yes, Your Honor.
Okay, your attorney is present here. Were you born in 1984, Mr. Carroll?
Yes, Your Honor.
Last four digits, social security number 1173.
Yes, Your Honor.
Okay, you're here for the purpose of arraignment. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging trafficking, controlled substance, Class C felony, possession of drug paraphernalia, possession of marijuana, failure to maintain insurance, failure to notify change of address to Department of Transportation, failure to provide insurance card, and be a persistent felony offender. Do you understand those charges?
Yes, Your Honor.
Yeah, I've given your indictment to your attorney. You acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, interplead not guilty, reserve all pretrial motions.
Yes, Your Honor.
Mr. Carroll, I'm setting you a negotiation day on April the 5th at 9 a.m. And your next court day will be on April the 25th. Your attorney will be up there to see you, and counsel, there'll probably be transportation orders for him to appear at the negotiations, okay?
Yes, Your Honor.
Okay.
Your
Bell
Your Honor-
County, yeah, go ahead.
Your Honor, I know this is unorthodox, but if I could just have a second of your time to, or the prosecutor's time, I think I can come to an agreement today and we could be done with it. If you don't care, Your Honor.
I advise you to not speak until you have a chance to speak to me.
I would just rather get this done with if you don't care. If the prosecuting attorney don't care to speak to me for a second, I will take time on this and be done with it.
Well, you're doing the opposite now. You're costing time, so please.
Well, here's what I want you to do. You're gonna come up, he'll come up and see you soon. And if if after you get his advice, if you decide to enter a plea, then I can get you to one of these other rule days quicker than waiting until the next month, okay?
Okay,
I think you'd be better off. I know you're impatient. I know you got problems, but I would feel better. And I think everybody, if you had an opportunity to talk to your counsel, and then we'll bring you up at one of these other rule days if you can reach an agreement, okay?
yes, sir. What's my counsel's name? That way I can call the public defender's office, to talk to him.
Well, he'll be in contact with you as Mr. Pennington.
Okay, thank you, sir.
Yeah, thank you. Bell County, thank you for cooperation. Y'all may be excused. Now let's go back to Bell County.
I think that.
That was Bell.
I mean, Barron County, excuse me.
You want to go ahead and take Mr. Duvall up so they can transport the prisoner?
Sure.
Yeah.
I think Mr. Brown's gonna have to get a school bus.
Yeah.
Commonwealth versus Joshua Duvall, 23 CR 0030. Are you Joshua Duvall? Were you born in 1985?
Yes, sir.
The last four digits is social security number 4641.
Yes, sir.
Okay, now this says it's motion for shock probation.
And Judge, if I could very briefly, I filed a motion for shock in this case. It is appeared now that Mr. Duvall has been granted parole. So his intentions to withdraw his shock and proceed with parole.
Well, I'm glad he finally made up his mind, because we had Mr. Murphy to go through a drug court assessment, because I thought he was going into drug court. I wish him well on parole.
Is that correct? He's paroled?
He's paroled up on next month.
Yes, Your Honor, I gave Mr. Stockton here the parole. He met with him in April and they recommended parole. Whether they decided to give it to him or not, I haven't been notified. They'll notify him first once they give him a day to be released.
So we're still holding until then.
Yes.
Well, I'll schedule him, reschedule him on April the 25th. And then if we have an order of release from the parole board, he can just leave then. Okay?
Thank you, Judge.
Great, thank you. Okay, now we're going to Barron County. Thank you, Barron County, for your patience. Barron County.
Ready, Your Honor.
Okay. This is Richard Armstrong. Commonwealth versus Richard Armstrong. Is this a Cumberland County case? Okay, we have two Monroe County cases all over there, I know. Commonwealth Kentucky versus Richard Armstrong, 23 CR 0080. Are you Richard Armstrong?
Yes, Your Honor.
You born in 2000?
Yes, Your Honor.
Last four digits is social security number 7619.
India?
We're here on a pretrial diversion revocation in 23 CR 0080. What does the Commonwealth have to say?
Your Honor, this is a possession of controlled substance, 3-year sentence. And the basis for the revocation is a new felony arrest, rape third, fleeing evading first, giving officer false ID, wanton endangerment first. If he doesn't stipulate, I'll need a hearing date, so I can subpoena the trooper.
And Judge, given that I just found out Mr. Armstrong was in Barron County yesterday, I've not had a chance to get over and meet with him.
Continue his case to April the 25th. If he wants to stipulate between now and then.
Certainly, I'll let the Commonwealth know, Judge.
Here, we got a Monroe County case, Commonwealth versus Hannah Lyons. Does Thomas J need any paper signed before he goes to this? Commonwealth Kentucky versus Hannah Lyons. All right.
They're done with you.
Mr. Armstrong, your lawyer will be over to speak to you in a day or two, okay? Commonwealth versus Hannah Lyons. Monroe Circuit Court, 24 CR 0002. Are you Hannah Lyons?
Yes, Your Honor.
You born in 1997?
I was.
Last 4 digits, social security number 6857.
Yes, sir.
Okay, the grand jury of Monroe County had returned an indictment, and you're here for a pretrial conference. You're represented by Johnny Bell. Mr. Bell? It's not a great day for classical lawyers to show up.
No, none look right.
Judge,
See Mr. Bell on the line?
Judge,
Yes, Mr. Garrett.
Johnny is up here in Hart County with me. I'll go let him know to get online.
Well, I'll just give him the phone there.
Okay, I'll have to go into the courtroom. Hang on 1 second.
Glad to be going to court.
Something to work together there.
It says it's a pretrial conference. Mr.
He's
Bell,
coming, Judge.
Mr. Bell, tell me what I've said previously. Mr. Bell, I have Hannah Lyons here, Monroe Circuit Court case, and it says we're here for a pretrial conference. What's the deal here?
Judge, I have failed to put that on my calendar or my schedule. I apologize to the court, but
When's the negotiation day, Monroe?
April the 5th at 9.
Here?
No, yes, here in Burkesville.
Okay, the Monroe County negotiation day is April the 5th at 9 a.m. here in Burkesville.
well, Judge, we have an agreement. We had an agreement on this case. That's the one we had done the diversion on, Judge, and then she didn't qualify because she had one. She had advised me she's willing to take a felony plea at the same requirements and go into drug court if that's something that's possible.
That's fine with me, Your Honor. Only trouble is I didn't bring my file because I didn't realize this was said either.
Are we anywhere next week? Or are we off?
We're here in Cumberland County 2 days.
What?
We're here in Cumberland County Monday and Tuesday. So we could do it either one of those days.
Yeah, can you be here Monday or Tuesday? Mr. Bell?
Judge, I will be well, you won't be there though. No,
I'm gonna be on the bench here Monday and Tuesday.
Could I do that? Could I get the paperwork done, Judge, and do that by Zoom?
Yeah, we'll send you the paperwork.
I'll go over to the jail and get it signed and then show up by Zoom if that pleases everybody. I've got conflicts on those days.
Okay, well, we'll send you an invite, okay?
Thank you, Judge.
Okay, thank you. Andrea Stinson.
Which day are we gonna do that on?
Let's do it on Monday. Okay, Monday. And we'll send Miss Lyons a He'll come over, Miss Lyons, we'll do it by Zoom on Monday, okay? Okay, this is Andrea Stinson.
Yes, sir.
This is 22 CR 0089, 23 CR 0054. Were you born in 1990?
Yes, sir.
That's 4 digits, social security number 1838.
Yes, sir.
We're here today on motion for shock probation.
And Judge, I'll kind of take the lead. We, excuse me, we started this on Thursday and Mr. Stockton had not had his file. Judge, we can take some test notes from Ms. Stinson if need be, but just to remind the court, she had tried to parole out, was given a 12-month deferral back in February. Part of it, to her, no fault of her own, she's unable to get classes there at Barron County with a teacher turnover. According to the Department of Corrections, she's a low-risk assessment.
What's the chart line chart?
Your Honor, this is the case from Monroe County. She's charged with wanton endangerment first in 22 CR 89. That was the plea, and tampering with a prisoner monitor device in 23 CR 454. She got 5 years on the wanton endangerment, 1 year on the tampering, for a total of 6 years.
What's your position?
I'm torn on this case, Your Honor. This is a case on the wanton endangerment. It was originally a criminal abuse amended to wanton endangerment. There was allegations that the child was malnourished. This is the case where it was finally settled. My understanding from talking to defense counsel, they never could locate an expert witness in the Commonwealth of Kentucky, so we reached a settlement on the case. And that's the reason she's got so much jail credit. She's got approximately 17 months in, 1 year and 5 months she served. She had about probably a year in when she entered the plea, close to it.
When will she be paroled?
She just came up for parole and it was denied.
With that deferral February of
wait a second.
It was denied. She was given a deferment for 12 months, so she won't be eligible for parole again until approximately February of next year.
Okay, now.
And that, Judge, that's what I was going to say. And Judge, with the amount of time, I mean, 1.5 years, Ms. Stinson already has approved placement from Officer Collins over in Monroe County. And Judge intends to open a business if given the opportunity.
What kind of business?
Cake business. Judge, she's a baker by trade. And
Where's
Judge,
the
I know
child?
Mr. Stockton,
Where's the child?
I think the cabinet has custody, but I don't know who.
her rights have been terminated.
Yeah, I don't know who has physical custody.
What do you have to say?
Well, she's been in a long time, Judge. She'll get out. I talked to Mr. Collins yesterday. He said that if we don't shock her, he's certain she'll be paroled out the next time. He has done a placement plan. She's gonna be living with a lady named Madison Harlow, I think an elderly lady. So I'm not gonna jump up and down the post at as much time as she served.
Okay, well, I'll agree, but she has to have a place certain to live. She has to be employed in this business. And I want some restrictions on her mobility, for a while, let's say for 3 or 4 months. I'd like her to be church work with doctor that first 3 months until they get her in a controlled situation. So I'll go ahead. When can you move into this new house, ma'am?
The minute I'm,
I couldn't hear.
You need to say it again.
the minute I'm released for the home placement, I can move in immediately.
Okay, well, I'm gonna go ahead and sign you a shock probation and
Your Honor.
for the first 3 months, I want you to be at home, church, work with the doctor. Now, if you're gonna start a business, I understand that you're gonna have to be traveling around. So to buy things or this or that, is the business gonna be out of this lady's home?
No, sir. It's actually gonna be in the same city. It's in the same city, just right down the road from where I will be living.
Okay, well, you can be there at that workplace or anywhere you need to get materials. But as they say in Monroe County, don't be out of gomming around.
Monroe County.
Okay?
Okay. Thank you, Your Honor, so much.
Okay.
Thanks, Judge.
Bond will be on the way. Barron County, do we have anybody else there?
No, Your Honor.
Thank you for cooperation.
Good, man.
Thank you.
If you could, be good in other areas. Range areas finished.
Okay, well, we'll bring them out there.
All right, thank you.
Okay, you need to, these prisoners here need to be, we can go over to this side here somewhere. Officer, you need to come over this side over here. We're going to bring your grand jury out. Thank you very much. Mr. Bailiff, will you go back here and let us bring the grand jury? I guess I need to turn the camera off. Sounds okay, but just get the camera off.
There's no picture of the Granger.
There's no picture of the Granger.
Okay. Bring the grand jury. Clinton County will be right with you. All rise for the grand jury, please. Okay, everyone can be seated. Madam Foreperson, have y'all completed your work?
Yes, sir.
Did you give it to the bailiff there? Have 9 or more of you voted on each one of these?
Yes, Your Honor.
Okay. Okay, everything seems to be in order. Here, I'm going to go ahead and initiate the process to have warrants issued. If the individuals are already in custody, we'll have summons issued. We'll review the bonds on each one of them. If we do warrants, I'll set a bond sufficient to assure their attendance or make sure the public is protected if there appear to be a danger involved. I would remind all of you that you need to keep confidential information that you heard in the grand jury. You hear a lot more than's on the indictment, so it's important that you not only not say anything about who's indicted or any of the information that you have. You'll next be back here on April the 25th unless called back in special session the grand jury because of an emergency or riot or insurrection. So these days you can't ever tell whether you're gonna have insurrection, you know, if you believe everything you see on the television. So thank you very much for your service, and we look forward to seeing you next month. You may be excused and go with the bailiff. He'll take you out. All rise to the grand jury. You get these. Thank you very much. Okay, everyone else can be seated, and we'll go to Clinton County Jail. And then we'll be in Adair County next. Adair County will be there in just maybe in a timely manner. Scheduled at 10:30. That's in 5 minutes. Clinton County Jail, Commonwealth of Kentucky versus Keaton Cross. 23 CR 00078. Are you Keaton Cross?
Yes, sir.
Born in 1999.
Yes, sir.
Four digits of your social security number, 1745. You're here today on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, the basis of the revocation, he's on.
Speak up. Just
He's currently on diversion on possession of controlled substance. He has a Clinton County indictment on possession of controlled substance where he's to be arraigned April the 14th. I'd like to set this for April the 5th at 9 a.m. to see if I can resolve both cases. That's all right, Mr.
we will set,
No objection, Judge.
we'll set a negotiation day here in Burkesville, April the 5th at 9 a.m.
Yeah.
And then you want to, and what's the Clinton County date over there?
He's set to be arraigned April the 14th, so.
Okay, that's before we have here, so let's have him over there on April 14th in this case too.
Maybe we can
If
resolve
you
both
reach an
cases.
accord. If you do a universal agreement, we'll do a transportation order over there. Sign some kind of agreement to combine them for judicial economy under the criminal rules. Okay?
Yes,
Your
Judge.
attorney will be over to get you. We'll have a transportation order, bring you to Burkesville, April the 5th at 9 a.m. for negotiation. Clinton County, do we have anybody else over there?
No, Your Honor.
Thank you very much for your cooperation. Carson, I guess that relieves you.
Thank you, Judge.
Yeah, glad to see you in uniform, Carson.
Hey, I made sure this morning I've seen that red shirt hanging there.
And have that orange uniform on like another prisoner. Okay, thank you.
Thank you.
We'll go to Adair County. It's, exactly at 10:30. Okay, we're in recess for a second. Y'all come back over here and sit down if you want to get a seat.
Got anybody else show some? No, what's up?
No, not sure.
Hey, no, you're looking rough, so I got to grab good, so I like wait. Okay. If time to call me, and I'll come back in.
That's still in process. They're not going to the streets.
Take them.
What's up?
And the Reed County tomorrow.
Me?
Yeah, bro. Yeah. But I didn't know to me, now we gotta go back. Oh.
I haven't been to, I was saying, where is Meade County?
It's right by the Ohio River.
I was thinking it was way over there.
I thought if you, I mean, they're gonna get, they take you like in the next.
Technically, go back today.
I'll be a minute.
It's gonna wait for my hours. Well, usually it's still down. Taking the day off. Long as we do that, I'll let my law, not that.
That's a railroad.
Pretty good.
You need to go security first.
Just got off my 5-day break.
You see you listen.
Mine says June 30th.
And you need time to reallocate.
Before to get land.
Yeah, I'm gonna go.
Actually, no, figure it out. No, you can take.
I'm just in there, you know.
Well, that ain't gonna work. She never did context. And so I don't think she wants to. This is the one I named.
Yeah.
There's huge mountain man. Maybe take out Carroll back down. No, I definitely have pretty good schedule worked out. I'm gonna golf 2 days, I'm gonna fish 2 days, I'm working my vehicles 2 days. And on Sundays, I'm gonna rest.
I'm gonna start my pre-retirement this after next, I'm gonna start my fishing.
So I have a plan too.
Okay.
I'm gonna work till I die.
Yeah, hopefully, I lived as long as Ollie, he was 82, my grandma was 85. So if I get to 80, I figure I'll get 20 years or 18 or 20 years of being paid for not doing nothing. And I'll break even then.
Well, between the saying, the good young.
Yeah.
And the saying that, people who are mentally wired, to curse, because that's, the more artistic kind of stuff. They say they live longer. I should be more.
Yeah.
That's my goal.
But now, how long have you been out of high school?
I graduated in 2000.
I graduated in 1981.
I was born in 82.
Now, here's what I see how my life has progressed. At 20 years out, I went to my 21st class reunions, and a bunch of people, drug overdoses, suicides, car wrecks even. And then I go back to 25th, and it was even long better and more.
Officer Moody, can you hear me?
So now, out of 115 people, or 117 people, 40 of us left. And
Okay.
We don't have one, so.
Officer Moody. Is somebody calling my name?
Yes, this is Jesse Stockton. We don't have a camera. I'm back here in Megan's office. Clerk. I'm going to ask you about Denzel Burton.
Okay.
The defense counsel gave me information that he went to a rehab. Was that with your permission?
No, I had no knowledge of him being in rehab. The last contact that I had with Mr. Burton is whenever I was working on transferring him to Allen County because he wanted to leave Victory Lane here in Warren County.
That was August of last year, according to the report I read.
Yes, that was last year, and I haven't had any contact with him since then. And prior to that, the only treatment to my knowledge that he completed was in March of 23. He completed Jinky's Journey, A Road to Recovery. And we have a certificate scanned in for that. But other than that, I'm not aware of any type of treatment that he was in.
Okay. Well, if you'll just be patient, we call his case, okay?
Okay, sounds good.
Let's go back on the record, please. We're going to Adair County. Commonwealth versus David Brinker. David Brinker, Adair County.
Yes, sir.
Okay, are you David Brinker?
Yes, sir.
Born in 1965.
Yes, sir.
Passport digit social security number 2619. We're on 23 CR 0067. What was the Commonwealth have?
We have found complete now.
Mr. Brinker, I've been told that you wish to enter a plea today. Is that correct?
Sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we identified previously in 23 CR 0067?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Do you feel like you're fully informed about the case?
Yes, sir.
You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes, sir.
Yeah, I'm gonna go over those rights and then I'm gonna ask, okay, you have the right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witness in your favor, the right to appeal this matter higher court if you lose, and the right to require the Commonwealth to prove on the reasonable doubt the guilty charge against you, that you understand about entering a guilty plea, they give up those rights. Do you understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will pre-sentence investigation report from probation and parole. In the event I don't accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea to guilty and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation if you speak up real firmly?
He will plead guilty to possession of a controlled substance, first degree, receive a sentence of 3 years, serve 30 days, balance probated for 5 years, probation be supervised, reimburse the Cumberland County Fiscal Court $434.07 for his transportation costs. He'll maintain gainful employment once he's released or do 30 hours community service and pay court costs at discretion of the court.
Okay, will 30 days be 30 days from today?
Well, that's problematic. I was telling Mr. Pennington, see, he was picked up through NCIC and I'm reluctant to let him be released before sentence.
Yeah, so we'll wait. Our sentencing is a little closer than is usually.
And Judge, in lieu of that, we would just ask if it be possible, and this might be a probation and parole question, if Mr. Brinker could be sentenced in Clinton on the 11th.
Can you get the report done by the 11th?
I'd have to ask Officer Foley, Bell, she's the PSI writer.
Bethany Foley?
Yes, sir.
You think you can get the report done by the 11th for Clinton County?
Yes, I'll have it done.
Thank you, officer.
Scheduling for the 11th. Now,
He's not gonna get released, is he?
not till then. No, not going to get released these sentences. Is
I'll give him the,
or is that your understanding of the Commonwealth's recommendation? Sir? That's your understanding of the Commonwealth's recommendation that you heard?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment as amended?
I'm sorry, one more time.
Are you pleading guilty because you did commit the acts charged in the indictment as amended? You did do the acts that you charged with. Is that correct?
Yes, sir.
Are you doing so voluntarily because you're guilty?
Yes, sir.
You know your constitutional rights. Explain to you is it still your desire to give up those rights and allow the court to fix the punishment within the range permitted by law?
Yes, sir.
And you understand that once you enter a guilty plea, any future convictions of felonies could be enhanced because of this conviction. You understand that?
Yes, sir.
Do you have the document he signed? Thank you. Is that your signature on there, sir? Can you see it?
Hang on a second.
Okay, I got all the time in the world.
Yes, sir.
Okay, thank you. Well, I'll accept the plea and order precinct's investigation report. You'll be sentenced over in Albany. I need to sign that thing. On the 11th, was that correct?
Yes, Judge. Thank
So they'll transport you over there that day. And probation and parole will be up to speak to you before then. Do you have additional days to serve after the plea?
No, he should have his time in.
Y'all have your time in, so possibly you might bring your stuff with you over to Clinton County and have somebody to pick you up, okay?
Yes, sir.
Okay, thank you. Stephen Bruce.
11.
Stephen Bruce. Commonwealth versus Stephen Bruce, 24 CR 006. You're here for the purpose of arraignment. What's your year of birth, Mr. Bruce? 1985?
Yeah.
Last four digits, social security number 0456.
Yeah.
You have a right to remain silent. You're represented by the Office of Public Advocacy. The grand jury of Cumberland County has returned an indictment charging you with possession of a controlled substance of first degree methamphetamine, possession of drug paraphernalia, and failure to maintain insurance and no operator's license. Counselor, you acknowledge the identity of Mr. Bruce, receive indictment, wait formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We will set up a negotiation day here in Burksville on April the 5th at 9 a.m. And your next court appearance is on April the 25th.
Really, you can't handle it right now?
Pardon? Hello?
Yeah.
Your attorney will be up to speak to you, Mr. Bruce. Did you have something you wanted to say or?
So you're telling me I got to sit here till April 5th to go back to court? I've been to court already. I wasn't arraigned then?
You just got arraigned then with the charges. The indictment was presented to you, you got arraigned, so you're now in front of this court. I've scheduled a negotiation day where your attorney and the Commonwealth will meet with you in person to see if y'all can reach an agreement on the case as far as a plea. If you can reach an agreement, you'll be back there on April the 25th, enter a plea, or we'll set you a trial date on April 25th. Now, if you did reach an agreement before then, there's possible we could work in one of the other counties before then if you reach a plea agreement.
I'll be able to speak to you soon, Mr. Bruce.
Okay? Denzel Burton is next. Denzel Burton. Commonwealth versus Denzel Burton, 22 CR 0058. Are you Denzel Burton?
Yes, sir.
Born in 1971.
Yes.
Last four digits, social security number 1609. We're here today on 22 CR 0058 on a probation revocation here. What's the Commonwealth episode? Mr. Stockton.
Yes, Your Honor. Yeah, this is a motion to revoke probation on trafficking controlled substance, first degree, got a 10-year sentence. He was probated, Your Honor, and absconded. I've got Miss Kayla Moody on to testify.
You want to stipulate?
No, Your Honor.
Miss Moody, you raise your right hand, Miss Moody. You swear testimony about to give us the truth, the whole truth, nothing but truth.
Yes, Judge.
You may inquire.
Miss Moody, which office do you work for out of?
I work out of the Warren County office.
And which county were you supervising, Mr. Burton?
Yes, I was supervising Mr. Burton in the Warren County office. He was transferred to me in April of 2023.
Okay, and you supervised him for a few months, is that correct?
Yes, I supervised him from April until July when he absconded at that point.
Okay, did he have any violations between April and July when you were able to supervise him?
The only violations that he had was failure to report to probation and parole and absconding.
And when was that?
So on July 11th, the failure to report, he reported into our office and was directed to report back on July 25th to check the status of his transfer to Allen County. At that point, Mr. Burton failed to report as directed. On August 16th, for the absconding, I attempted to contact Mr. Burton at his last reported number, was not able to make contact. On the 18th, Officer Luce and Officer Wozni conducted a home visit to Burton's last reported address in Allen County. There was no contact made, although there were 2 vehicles in the driveway. A door tag was left instructing Burton to report to Officer Moody in the Bowling Green office on August 18th of 2023. At that time, Mr. Burton made no efforts to make contact with probation and parole. I checked local jails and hospitals and there were negative results.
And after this July 11th date, he never reported back to you, is that correct?
No, I had no contact with Mr. Burton.
Were you aware of reporting to any other probation officer in Allen County or anywhere else?
No, I was not aware of that.
I don't think I have any further questions, Your Honor, at this time.
You may inquire.
Yes, Your Honor. So, Officer Moody, can you hear me okay?
Yes, I can hear you.
I think one of the things you testified to a moment ago is that you check local jails and hospitals, correct?
Yes.
And you do that because if an individual's there, it's hard for them to report and check in, right?
Correct.
Are you aware that Mr. Burton was at a sober living facility in Morgantown, Kentucky in August of 2023?
No.
Are you aware of that fact now?
No.
You've made me aware of it.
You have any testimony you want to offer on that, or should I swear you again? So.
No, Judge, there's some people from sober living here. We'll swear them in just a second. Those are the questions I have, Officer.
Okay. You have anything else for the officer?
Just one question. Do you know when Mr. Burton was arrested on your probation violation warrant, Ms. Moody?
It shows that he was picked up on 3/6, so March 6th of 2024.
Okay, I have nothing further, Your Honor.
I'm just, as far as process, officer, I have a question.
Uh-huh.
Go ahead.
What? Oh, I didn't. I think I set my pen down, Judge. I didn't have anything. Sorry.
Is it the practice of probation and parole to allow someone to avoid reporting to probation and parole officers by just admitting themselves to some treatment centers?
No, they are to make us aware of, where they're at as far as treatment and things of that nature. Typically we receive bed letters or something so that we know where they're at all times. So we don't just, allow them to not report. They have to keep us updated on their address or where they're at.
Okay, thank you very much. May this officer be excused?
Yes, sir.
You may be excused. Thank you.
Thank you, Judge.
Yeah.
No, it's all the witnesses, Commonwealth.
Judge, I actually have a witness from the sober living.
Well, here's the thing. If the Commonwealth stipulates the fact that he was at some sober living place, okay, let's just say that he was there. Do you think that that relieves him from his responsibility of reporting to the probation and parole officer or having a letter of admission or them approving him going into place and changing?
Judge, not ordinarily, but I think the testimony will be that Mr. Burton was in a crisis unit, so I think that might mitigate some of his ability to contact individuals. I don't know what a crisis unit pertains to, but I'm sure these people from the rehab or Mr. Burton can attest. I don't know what kind of condition Mr. Burton was in for a long period of time, so.
Can I speak, Your Honor?
Mitigation would be when he was mentally, physically, or emotionally able to reach out to probation and
If
parole.
we're gonna offer that type of proof, I wanna see the records and see if I need a witness, because that's getting into his mental health, mental defect. I don't know. I mean, I don't, are these people doctors at the rehab?
I think that you just can't offer this testimony without giving some notice to the Commonwealth. I'm not going to deny your ability to introduce it.
Judge, my notice was this.
Well, I'm not blaming you. I'm just saying out of a sense of fairness, you ought to provide what the testimony is going to be and see what it goes. So we will continue this hearing, pick it up at this point where we are now, and you get within 5 days. I'll give you 10 days, give 10 days, give full reports and records from this rehab, any statements you have from them, any records they have, and we'll continue this hearing on April the 25th.
Yes, Judge.
Okay? Thank you very much. Mark Cruz.
Mr. Cruz was picked up yesterday for Grayson County. He had court down there.
Okay. We'll continue him until April the 25th for arraignment.
Okay.
Is he coming back to Dare County?
Yes, he should be back later on today or in the morning.
Okay, well, we might schedule him for arraignment at one of the other venues over in Clinton or somewhere. So if y'all will kind of trace him. Okay.
I think he'll be a DPA.
Michael Graves.
He's at our Class D. They should be on.
If not, he won't.
Michael Graves. There you go. Are you Michael Graves?
Yes, sir.
This is 23 CR 0060. Were you born in 1972, Mr. Graves?
Yes, sir.
Last 4 digits of your social security number, 9793.
That's correct.
This is 23 CR 0060. It says motion for shock probation. What do we have here, Mr. Cross?
Your Honor, Mr. Graves, requesting conditional discharge. What we've proposed to do is reimburse the Commonwealth, the Sheriff's Office in the entirety for their effort in going to Florida and having to pick him up. And Michael would agree to go into whatever kind of rehab program, minimum 90 days that Commonwealth would agree that he do.
What's the charge?
It's a possession case, Your Honor.
What?
It's a 3-year sentence on possession. He's up for parole in May.
And he was in a rehab, had some issues with them and left and was real stupid instead of coming
Think
in.
he'd be better off to wait till May to see if they parole him?
Well,
I mean, it's a lot less restrictive as far as the conditions of parole than it would be to extend his probationary period out.
well, I've been asked to make the motion, Your Honor. If he's not paroled, I'd make it again after May. If you don't grant the motion. I thought Sheriff Williams might want some of his money back.
Yeah, the transportation costs, he still owes for that when we picked him up in CI.
Well, how long was he a fugitive?
A couple of weeks, probably.
Yeah, I'll take that back. I don't think we picked him up on CI.
Oh, no, well.
We had to have him transported from somewhere.
From Florida.
Yeah, that's correct. He was the one that allegedly took his father's car and they had to go to Florida.
Right.
Yeah, I remember the case now. So I wouldn't have any objection if he wanted to pay that money up front for the shop.
No, I think he can do that.
How much money is it?
I can't remember. It's $700 or $800, I think.
I believe if that's a condition, I think Mr. Graves is able to do that, Your Honor.
If he pays the money back on the transportation costs, how long has he been in jail?
3 months, I'd say.
See, I'll shock probate him. If he pays the transportation costs back up, I'll sign him immediately and he can get out post-wit, but he still needs to, will need to meet with the probation parole officer. When can he meet with you, officer?
When is he planning on being released after he pays that?
Mr. Graves, when do you think you'll be able to pay that money so I can set you an appointment up with the probation parole officer?
Pay it today or tomorrow.
Okay, well, I'll tell you what, you pay it in the morning and when you pay it, they'll receive the money there. You can be released and go with the probation parole office there in Columbia immediately upon your release, okay? And he'll give you the conditions and sign you up and everything. You can be on your way rejoicing, okay?
Thank you.
So have them bring the money down here this afternoon or in the morning, and when they do that, the order will be signed, okay?
Yes, sir. Thank you.
Try to comply this time, Mr. Graves, so I don't have to send you back, okay?
I will.
Okay, Sammy Holland. Commonwealth versus Sammy Holland. 23 CR 0076. Are you Sammy Holland?
Yes, sir.
Were you born in 1985?
Yes, sir.
4 digits of your social security number are 8437, correct?
Yep. Yes, sir.
Probation revocation, what does the Commonwealth have to say?
We have.
You need to be, yeah.
It's a 3-year sentence on possession of controlled substance. According to the probation officer, he absconded November 23rd and was arrested March the 4th. I have Ms. Hayes here to testify.
You want to stipulate?
We'll need testimony, Judge.
You raise your right hand. Swear the testimony about to give us truth, whole truth, nothing.
Yes, I do.
Go ahead. Scott.
Ms. Hayes, which office do you work in?
Madison County, 25th Judicial District.
And was Mr. Holland living in Madison County when you were supervising?
He was transferred to my caseload on November 21st of last year.
Okay, what happened after he was transferred to your caseload?
He was, upon accepting his transfer, I gave him reporting instructions to come to the office on the 28th of November of last year. He reported he was staying at a local hotel. It's a common one that many of our offenders do live at, so we do accept transfers for those. He understood his reporting instructions, and then on the 28th, he did not report to the office as instructed. I contacted him via telephone, instructed him to report on the 29th of November of last year. On the 29th, he did report to the office, but due to scheduling conflicts, I had to reschedule him for December 4th. Again, on December 4th, he did report to the office as being as instructed. Due to me being out of the office on that date, I had to reschedule him for December 6th at 9 a.m. He had told the officer he understood. On December 6th, he did not report. On December 7th, I made contact with him via telephone and instructed him to report on the 13th. I apologize for him having to be rescheduled multiple times due to no fault of his own. On December 13th, he failed to report. On December 14th, myself and another officer conducted a home visit at that local hotel at the reported room he was residing in. The curtains to the room was open and we were able to see inside, and it appeared to be a storage room. There were multiple tables and chairs in there. We left a tag in the door for him to report to our office on December 15th by 8 a.m. On December 15th, he failed to report. And on December 20th, I conducted a check of local hospitals. He was not a patient at either of our local hospitals, and he had not reported to the office or attempted to make contact at that point. So he was declared absconded, and we got an active warrant for him on January 3rd, I do believe it was.
Okay. And at some point in time, was he arrested?
He was arrested on that warrant. I got the notification on March 2nd of this year.
Okay, and what did you do after you got a notification on the warrant?
Whenever we have an out-of-county person, they are actually transferred to their sentencing county. So I was notified by the officer whose caseload he was returned to was Officer Garner. Officer Garner had conducted a drug test and had notified me that there would be an upcoming revocation hearing and I would need to attend.
Okay, I have no further questions this week.
Would you like to inquire?
Yes, Your Honor. So Officer Hayes, if I'm understanding correctly, you had some scheduling issues and had to reschedule some appointments for Mr. Holland, right?
That is correct.
But he did in fact actually come to the probation and parole office in the months of November and December, right?
He did report. We were just unable to get his case set up and sign his conditions of supervision as we needed to.
And I wrote this down. You said no fault of his own, right?
No fault of his own for the two that were scheduling conflicts, yes.
That's all I have, officer.
I have no
Thank
further
you.
questions.
She may be excused, officer. Thanks for your attendance.
I'd like to call
Thank
Officer
you, Your
Garner.
Honor.
Officer Garner, will you take a stand there? Swear the testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Have a seat, state your name.
Officer Garner, probation and parole.
Officer Garner, what involvement did you have in this case with Mr. Holland?
When Mr. Holland was brought back to my caseload since I'm out of the sentencing.
That microphone is not kicking for some reason. Maybe you have to get closer to it.
Can you hear me now?
I can hear you, but it's not kicking the camera over there. Go ahead.
Okay, so, Mr. Holland was put on my caseload, upon, returning to the, him being incarcerated since we're the sentencing district. I had requested that officers at a local, probation office conduct a urinalysis, once I was notified on 3/4/24. I was notified that Mr. Holland picked up on probation violation of absconder warrant and was lodged in the Madison County Detention Center located in Richmond, Kentucky. This officer requested assistance from officers from the closer district. On 3/6, Officer Stephen Willoughby conducted a urinalysis on Mr. Holland in which Mr. Holland tested positive for, admitted to, and signed an admission of guilt form to the use of methamphetamine occurring on or about 2/22/24.
Nothing further.
Would you like to inquire?
No, Your Honor.
No other witnesses.
Judge, just arguments, and you'll stand on proof if I may. Go ahead. Judge, if we're taking Officer Hayes' testimony at face value, there were multiple attempts by Mr. Holland to come in to report probation and parole, and he was told to come back another day. Now, I'm not going to try to make an excuse for his substance abuse use. But Judge, that speaks to a man needing rehabilitation or something to help him, not jail or prison. So Judge, if we're looking at just the absconding, which was the initial alleged violation, Judge, he reported in November, reported in December, and was told to, come back another day. So Judge, we're just asking for rehabilitation for this young man.
Well, he actually failed to report 3 times and he got rescheduled twice. I counted them up. And then after December the 14th, he was in the wind until March the 2nd, March the 4th. And it reminds me when my dad used to run a little store, somebody would come up to pay him on the street. He'd say, well, I don't have my bill with me right now. And the old folklore back then was, I guess, if you tried to pay somebody one time, then you didn't know them. I don't know if you've ever heard that, Judge, or not, but I guess because Mr. Holland thought that he'd been there twice and had to reschedule, that he just didn't have to comply. So I'm going to ask that he be revoked.
Anything else?
No, Your Honor.
I'm going to revoke him. There's drug use here. There's absconding. I mean, I'm sure he was frustrated. He went there a few times, but if you go there, anytime you go to probation and parole and they reschedule and you get to leave, that's a good day. They don't keep you. And you need to cooperate and come back. Probation is not a right, it's a privilege. And to exercise that privilege, you gotta cooperate. Okay, thank you very much. Lance Humphrey. Lance Humphrey. Commonwealth versus Lance Humphrey.
Yes, sir.
CR 0013. No, excuse me, 21 CR 0018 and 22 CR 0057. Mr. Humphrey, were you born in 1996?
Yes,
Last 4 digits social security number 5319.
I think so.
Yeah. Well, we're here on probation revocation on those two cases. What's the Commonwealth have to say?
Your Honor, Mr. Humphrey has a 10-year sentence on 21 CR 18, 2 counts of assault, third, and burglary for a total of 6. I'm sorry, has a 10-year sentence total. That's a 6-year sentence. Then
Those aren't, Mr. Stockton.
Lance, don't say anything.
22 CR 57, he has escaped second, tampering with prisoner monitor device. That's a 10-year sentence, and they run concurrently for a total of 10 years. And I can have Mr. Garner testify, but during the time he was on probation, parole, he went to rehab. He left the rehab against medical advice. He never made it back to Mr. Garner. That's one of the basis of the testimony.
They were taking me on a trip to Louisville, and the driver had a warrant. They pulled us over at Walmart, and the driver had a warrant, and they took him to jail. So I just went to Burger King, and I called my family to come get me, because I just was in the middle of nowhere.
Okay, well, we'll get some testimony here. Sure. You'll come over here. You raise your right hand, Officer Garner. You swear the testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, sir.
Officer Garner, how long have you been supervising Mr. Humphrey?
Mr. Humphrey was placed on supervision on July 30th, 21.
Okay. Now, let's go back to his current violations.
Okay.
And what precipitated, at some point in time, was he sent to a rehab?
Yes, let's see. I don't think I have when he was sent. I think he was sent out of the Cumberland County Court in lieu of revocation during his last hearing. And then
Was that mental health treatment or substance?
it was a dual diagnosis, substance abuse and mental health.
Okay. And did he stay in that mental health treatment facility, dual diagnosis facility?
No, I got notified on 3/7/24 that Mr. Humphreys left against medical advice, and because he refused to comply with the disciplinary actions, this officer received a call from a Berea, Kentucky police officer stating that Mr. Humphreys' family was meeting him at the ARC transportation to transport the driver to a halfway house. During the transit, the vehicle was pulled over and the driver was taken to jail for a warrant. However, Mr. Humphrey was left stranded in Berea. I did contact Mr. Humphrey's mother, and she said that she had no idea that he was leaving and that she was not coming to pick him up, that she didn't know he even left.
What was her demeanor when she
was very distraught. She was very upset because she was worried for the safety and the welfare of Mr. Humphreys and the community, because she was worried that either something's bad going to happen to Mr. Humphreys or to somebody else.
So what happened then? What did you find out?
I asked her if she had any way of finding out where he was to locate him. She ran his prepaid debit card that she has access to, and she confirmed at 10 o'clock that night that he had found his way to Columbia, where he had used his prepaid card at a gas station. But as far as that goes, that was the very last interaction that anybody had had with him. We haven't heard seen from him since.
Lance, don't talk.
And he didn't report to your office?
He did not.
Even though he used this debit card in Columbia?
Yes, sir.
Okay. And then was he later picked up and arrested on this warrant?
He was.
Okay. And was a urinalysis conducted once he was picked up on March 15th?
Yes, I went to the Adair County Regional Jail and conducted a urinalysis on him. He tested positive for Suboxone and benzodiazepines. He said that he was given that as a prescription at the facility that he was at. I confirmed with the facility through a records check of all his medications that he was prescribed. He was prescribed Suboxone, so that's not a violation. But they did not prescribe him any benzodiazepines, so he took benzodiazepines without a prescription.
Okay.
I didn't take anything. I had some in my medicine I might test for right now. I don't take.
If Mr. Humphrey's probation revoked, would it be your recommendation that the court order mental health treatment while he's incarcerated?
I would. If with his length of sentence being over 5 years, my recommendation would hopefully be that he would get to KSR where they have a medical unit that would address mental health.
I have nothing further on.
You have any questions?
I do. So, officer, you said you administered a drug test to Mr. Humphreys at Adair County,
Yes, sir.
and he was positive for Suboxone
Yes, sir.
and
Benzodiazepines.
when you did the records review check, was Mr. Humphreys also prescribed mental health medication?
The mental health medication that was prescribed, I had the social service clinician go through it and verify that there was no benzodiazepines listed in any of those medications.
And thank you for that. Gets to part of my question. So when you drug test Mr. Humphreys, did any of those mental health drugs appear in his drug screen?
No, because the mental health drugs that he was taking, as far as I'm aware, we don't test for those specific drugs, only the controlled substances like benzodiazepines, which is a mood stabilizer medication.
So the mental health drugs would have to be controlled for them to hit on your drug test.
Right.
Testified in where you were using driver and some of the pronouns. I just want to get this clear. So Mr. Humphreys leaves the rehab, is on his way with a staff member to a sober living.
My understanding, I've heard two different stories and I can't validate to which is correct. The one story was that he was going to a sober living and the other one he was meeting his family, but his family did confirm that they had no idea that he was even being released or that he was leaving. And the facility didn't say whether or not he was going to a sober living home or not. So I don't have verification on where he was going. I just know that the facility was transporting him somewhere and the driver was picked up.
And taken to jail.
The driver was, yes.
And then Lance is just stranded in what, Berea?
Berea. That was the word from the police officer out of Berea that called me.
And somehow makes it to Columbia.
He does.
And radio silence.
Radio silence.
Thank you, officer. That's all I have.
I don't have anything further. You may step back. You have any other witnesses? No, Your Honor. You have any other witnesses?
No, Your Honor.
Okay, what do we have?
Your Honor, the Commonwealth is going to ask that Mr. Humphrey's sentences be revoked. The reason Mr. Humphrey was at this dual diagnosis rehabilitation center was because of his mental health issues and because the court had him placed there because in lieu of revocation on his second motion to revoke. You've heard testimony that his family can't do anything to help him. He needs mental health treatment, and the only way he's going to get it if he's somewhere where he can't leave. And I would ask that he be revoked and the court issue an order that include mental health treatment at the Department of Corrections.
And Judge, that probably the last part is what I agree with Commonwealth is I think we're in agreement that this young man needs mental health treatment. I don't believe that he's going to get the level that he needs incarcerated. Judge, if we take Officer Gardner's testimony at what it was, we really don't know what happened. But we do know that a staff member from this rehabilitation was transporting Mr. Humphrey somewhere. His family says, well, he wasn't coming to get him. But the alternate story is they were taking him to sober living.
Well, there's one key fact being left out. He left the facility against medical advice. Yeah, they were transporting him after he decided to leave. And as long as he has that option.
Of course, we're talking about, you're wanting to talk about stuff that's not in the record.
Well, no, Officer Gardner testified to those facts.
Said he didn't know.
So you heard two stories. And you didn't know which one of them was. So you're gonna pick a story you think's better.
What Judge, if the family's saying we weren't coming to get him, and one of the stories is family was coming to get him.
You know,
And Judge, I think if
Go
we're,
ahead with your
and
argument.
if we're talking, again, Mr. Stockton is getting to the need for mental health. So if we're talking about an individual leaving to get medical advice, what state was Mr. Humphreys in when he left?
I don't know. I don't know what he was.
And
No testimony.
So Judge, I don't know what the answer is here. But
well, on that, you and I agree. You know, but the problem is here. What's the probability of you getting transported somewhere and the police arresting the guy that's transporting you? I mean,
Yeah.
I've never been practicing law for 40 years. I've never heard of that happen.
Kind of shows you the problem we have with all these unregulated rehabs.
That's exactly right.
I think, Judge, that might get in.
Well,
maybe the point finger at me.
yeah,
I was the
but
one that
then
got
he never
Mr.
came-
Humphreys
then
there,
He never
so.
came back though, see, he never came back. That's the problem that bothers me is he absconded.
Judge, he's
Maybe-
in Columbia
maybe
right,
that-
he's in Columbia right now. So,
Well, yeah, I know why he's in Columbia there, because we put him there.
but to say he wasn't coming back is.
He absconded. He did he ever report
He
back?
never reported, no.
He was arrested. Now, I've got sympathy for Mr. Humphrey. I want to do something to help him. I don't think he's a hardened criminal. I think he's got a drug problem, but I don't think that he can be, and a mental problem probably. But I don't know what to do with him other than revoke him. But the problem that I've got is even if I revoke him and put in the order that he's directed to get mental health evaluation stuff, I have no certainty Department of Corrections will recognize that.
No, but I do know something that's certain. I know if you don't revoke him, he will not comply with his probation and he won't get the treatment he needs.
Well,
I know
have
that's
no-
a
I have
certainty.
no
He's
doubt
proven
about
that.
I have no doubt about that.
Yeah.
So I'm gonna take the avenue that would protect Mr. Humphrey and hopefully get some treatment. And I'm gonna revoke him and put in the order, make sure it's a strong order, okay, that says that he'll get, looks like he's a dual diagnosis person and he needs treatment. Okay, Clara Lindsay. Thank you, Mr. Humphrey, for being cooperative. Clara Lindsay. Clara Lindsay. Commonwealth versus Clara Lindsay, 24 CI 013. Are you Clara Lindsay? You're here today for the purpose of arraignment. Miss Lindsay, what was your year of birth?
1988.
Okay, and the last four digits of social security number appear to be 1510. Is that right?
Yes, sir.
Okay, you have a right to remain silent. Your attorney is here. The grand jury of Cumberland County has returned you an indictment charging you trafficking controlled substance, first degree, first offense, possession of drug paraphernalia, possession of marijuana, being a persistent felony offender. You understand those charges?
Yes, sir.
Counselor, do you acknowledge the identity of your client? Receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Let's schedule a negotiation day for April the 5th at 9 a.m. here in Burkesville. Be a transportation order to bring this lady down here. And the next court appearance is April the 25th. Now, what kind of bond does she have?
It's from there, I'm showing a 5,000 cash or tons of property.
And what was that? She has some FTAs or something?
She's coming back as a moderate in both categories, sir. A moderate 5 to reoffend and a moderate 2 for FTAs. Looking at her report, it appears that she had a prior misdemeanor conviction, a prior felony conviction. Some prior FTAs.
When was that? FTA.
Your Honor, it was, Evanston County at 19 CR 49. It looks like she jumped up here January 24th of 2022. Then there was a violent offense conviction. At least 27.
If you want a bond reduction, you can file a bond reduction.
Certainly, Judge, and just a point of order, I believe that Miss Lindsay is also a co-defendant with Mr. Carroll. So I anticipate needing conflict counsel. I'll send that email today.
Okay. Thank you very much. Brandy Metter.
Yeah, you can file for a bond reduction.
Come on versus Randy Metter. 19 CR 00078. Are you Randy Metter?
Yes, sir.
Born in 1980.
Yes, sir.
Last four digits, social security number 2068. We're here on a probation revocation. Mr. Stockton.
Yes, Your Honor. He has an 8-year sentence, theft by failure to make required disposition. It's a motion to revoke shock probation. And I have Officer Jackson from Edmonson County, should be on Zoom to testify.
Officer, you raise your right hand, please. I swear the testimony about to give is the truth, the whole truth, and nothing but the truth.
I do, sir.
Thank you for
Mr.
waiting.
Gray, will you turn your camera off to your call? Okay, go ahead.
Thank you for waiting, Officer. Where are you employed?
Edmonson County Sheriff's Department.
Okay. And how long have you been a police officer?
Right at 2 years, sir.
Okay. Did you have any contact with the defendant, Randy Metter, on February the 5th, 2024?
I did. We were assisting KSP going to a call when we observed Mr. Metter standing outside of a residence he'd been known to stay in the community here in Edmonson County. The sheriff, James Vincent, and myself, Chief Deputy, had radioed me that he believed Mr. Metter had active warrants on him. Turned around, stopped and spoke to Mr. Metter. It was confirmed that he did have active warrants. At that time, I'd asked Mr. Metter if the complaints from the community we had about him firearm possession or in his bags or vehicle that he had been known to have based on those complaints was present with him. He said no. He gave consent to look in his bag, which is in the back of his female companion's vehicle. She gave consent to look as well. There was nothing inside of Mr. Metter's bag. At that time, I asked his female companion whether the firearm had been around Randy. She said there's one in the house. I asked her to show me where it was. She took me inside the residence. It was inside of a wood stove in the kitchen area of the house that he had been staying at with her. Once I got Mr. Metter back to the sheriff's office, I questioned him about it. He said, yes, there was a firearm in the house. He had asked her to remove it at one time in a previous time he had stayed with her. He stated that it was next to the bed in a nightstand. He had took it out and actually touched it and placed his hands on it. He had asked her told her it needed to be removed. He never gave an exact date or time of when that was, just a previous time that he had been staying at that resident with her. She confirmed.
What type of firearm was it?
It was a turquoise semi-automatic handgun. I'd have to go back and look at the evidence log to see the brand.
The citation says 9mm. Is that correct?
Yes, sir.
And was it loaded or unloaded?
If I recall, it did have one, the clip was in it, and there was not one chambered at that time.
Okay. And did he deny that was his gun?
He said it was not his gun. He was aware that it was there. He was aware he was a felon. He knew it shouldn't be in his area. And like I said, he had asked her previously to remove the firearm. Why she chose not to and why he chose to go back to that residence, I'm unsure. We'd had a few community complaints from anonymous callers that Mr. Metter had made some threats to use a firearm. I couldn't confirm those complaints, but the description did match the firearm that was in his female companion's home.
Okay. Now, was that the type of call you were answering, or was that a different type of call?
We were going on a assist with KSP in Grayson County to possible locate a suspect that had been involved in a murder at that time.
Okay. Now, also, Mr. Metter was charged with menacing and disorderly conduct. What caused you to bring those charges?
He had gotten very aggressive multiple times after I'd asked him not to at the sheriff's department. He had made some verbal comments towards myself, and he got extremely unruly at one time. I don't know that if he was just upset at the situation, but I'd asked him multiple times. I'd gave him numerous warnings with other officers and other people here at the SO during that time. He failed to understand my concern that he was going to get charged.
Was he making verbal or physical threatening gestures?
It was more verbal. It wasn't actually physical.
Okay. Okay. I don't think I have any other questions this witness, Your Honor.
So is it deputy or sheriff?
Who, me?
Yes.
I didn't understand all your question. I'm the sheriff's deputy.
I was wanting to get his title correct. So chief deputy, I have a few questions for you.
Okay.
So you said Mr. Meter was getting verbally aggressive with you?
Yes, sir.
Not physically, verbally.
No, he wasn't allowed to be physical, sir.
And this was after you arrested him?
That was during the arrest and after he was here at the SO. Yes, sir.
Those statements that you talked about Mr. Meter and his significant other making, were those recorded?
We do not have body cams, no, sir.
And you said that this was a place where Mr. Meter was known to stay, correct?
He was, to my understanding, it's where he was presiding in Edmonson County for quite some time.
Was that the only place he stayed in Edmonson County?
That was the only female he was dating, to my knowledge, in Edmonson County, so I'm assuming so.
In that case, with the possession of a firearm, menacing and resisting arrest, that's currently ongoing, right?
I think my understanding that he took a rocket deal here in Edmonson County on that charge. Last Tuesday.
That was showing that he had a court date on May 23rd. That would be wrong?
I'm unsure.
I'm not sure about the relevance of this. I'm not blaming. We're talking about this same case. Okay, sorry.
Thank you, Chief Deputy. Those are all the questions I have.
Can this officer be released?
He may.
Officer, thank you, Chief Deputy, and you may be released.
Thank you, sir.
Yeah.
I'd call Officer Bray, Your Honor.
Officer Wesley Bray, will you turn your camera on, raise your right hand? Officer Bray, you swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Officer Bray, are you familiar with Mr. Metter?
Yes, he's on my caseload.
And was he on your caseload when this alleged violation occurred on February 5th, 2024?
Yes, he was.
Now, I'm curious, he was in Edmonson County and you supervised out of what county?
Barron?
Did he have permission to be in Edmonson County?
No, he did not. I was unaware that he was staying there.
Yeah. What types of conditions was he under as far as his mobility and travel?
Well, his general conditions say he's the area of supervision is Barron County. Obviously, if he's on my caseload, I only supervise Barron County, so he's only supposed to be in Barron County.
So you didn't give him permission to go to Edmonson County?
No.
You didn't put in a transfer for him to be transferred so he could live with his girlfriend up there, did you?
No, sir.
Okay. And how long had you been supervising him since he'd been out of jail the last time?
He had been supervised by me he started with me because he went to Edmonson County. I started supervising him and then he went to Edmonson County and then he transferred back from Edmonson County on he transferred back on about the 18th of December. I approved the transfer on the 14th of December, 2023. So I've been supervising this time since 14th of December.
Had you met with him since then?
Yes,
Okay. And was he otherwise in compliance on his probation?
as far as I could tell, yes.
How many times did you met with him since December of 23?
I met with him. Twice before he was arrested, looks like.
Okay, so you met with him twice before he was arrested on February the 5th?
Yes.
Okay. I have nothing further, Your Honor.
Yes, Your Honor. So Officer Bray, can you hear me okay?
Yes, sir.
You said that Mr. Meter was transferred to Barron County in December of 2023, right?
Yes, sir.
And before that, he was supervised out of Edmonton County, right?
Yes, he had moved to Edmonson County. To my recollection, he had moved to, I think it was, I did a transfer on September 5th of 2023, and he was going to live in Brownsville. So it looks like his girlfriend, with his girlfriend.
And then in December, he was changing his residence to Barron County?
He transferred back in December, yes.
Okay. And as part of transferring, do you go out and look at the home?
Yes.
So you went to Mr. Meter's house there in Barron County?
Not, I don't think I went that time because he had lived there previously. And so I knew the residents, I knew he lived there, and I'd been out there previously. So I accepted the transfer when he reported.
So he lived in Barron County before, had a house there?
Yes, he had lived in Barron County before.
And in the 2 months that you, or the 2 visits that you had with him, no problems?
No problems that I can recollect.
As part of a transfer, you have to reach out to the other probation officer.
Are you talking about when I initiated transfer?
Yes.
What we do is the offender will come in. He will say, I'm requesting to move to wherever county he wants to. There's a form in our system that we do electronically, in-state transfer request, and we put that in-state transfer request to the district and the county that he's supposed to be transferring to, and then the office administrator in that office will assign that to a particular officer for that county, and then that officer investigates it. There doesn't have to be any verbal communication between officers.
Hypothetically, if there's an individual that's causing problems in another county, are the transfers approved?
Most of the time, no.
Thank you, officer. That's all I have.
No redirect.
Your Honor, I have a couple. Your Honor, I have a couple questions or something to ask Mr. Bray. If y'all don't mind, please.
Counselor, you care?
Go ahead.
Go ahead.
Wesley, do you remember the last time that I reported it? I asked you if I could go to Joanna's house to pick up the rest of my clothes and some of my property, my fishing stuff that was there.
I'll have to look back through my notes.
Because that's the day when I asked you, when we were in your office, I asked you because Dad had open heart surgery.
Did you say it's your dad?
Yeah, when Dad had open heart surgery, and I told you I lost Mom. We buried my mother, and I asked you when I was up there after I get everything took care of, that I needed to go up there and get the rest of my belongings. Bag of clothes, my book bag, and some other property, my fishing stuff that was up there. And you told me that was fine and I told you after I got Mom settled, And after Dad had open heart surgery.
I don't remember that particular conversation. I'm not saying that it didn't happen. I just don't remember it.
Yeah, because we were standing at the window and I signed my entry papers with you.
Yeah.
And I asked you that and you told me, you said you understood about Mom, me losing my mother. And
I do recall something about your dad having surgery and your mother and stuff. I
that
don't
was the
recall.
only, that
I'm
was
not
the
saying
only
you're
reason.
lying about that. I just don't recall it.
That was the only reason that I went up there, because I asked you, and I've always asked you, and even with Jason Alexander, before I done anything or went anywhere out of the county.
So that's
why.
So you said that was when you reported last time?
The last time I reported, sir.
Because the last time you reported on 111.
Yes, sir.
So you're saying you were there, you waited almost a month to go over there and get your stuff?
Well, I was dealing with my father having open heart surgery.
Okay.
Somebody still has to sit there with a man.
Wait. You asked if you could ask the question. And if you want to testify, you're gonna have to be sworn in. Right?
That's fine.
Okay.
You want to testify, I'll swear you in.
Yes, sir.
Please.
Raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Counselor, you want to ask him?
Certainly, Judge. Randy, you've heard everything this morning, right?
Yes, sir.
So first, I want to talk about the gun that allegedly was in your significant other's home. Is that your gun?
No, sir.
When Sheriff Deputy, Chief Deputy testified, did you tell him those things?
No, sir. He kept telling me when I was sitting in the sheriff's department that it was my gun. And I told him, I said, Tim, that's what you want me to tell you, is it's my gun because you want to put me in jail. And he said, yeah, we're going to do everything we can to put you away for the rest of your life.
Brandy, is that gun case still pending in Edmonson County?
Yes, sir.
Plan on fighting those charges?
Yes, sir, I do, because my fingerprints and the gun does not belong to me. I was sitting in a driveway in a vehicle. And I had no recollection of the gun being in the house.
Were you staying with your girlfriend there in?
No, sir, she's not my girlfriend. It was my ex-girlfriend, but I did transfer up there. Me and her got into a altercation because she wanted to stay drunk all the time. And I told her I was not supposed to be around it. I wasn't going to do it. And I explained that to Officer Bray when I transferred back. That was the reason I wanted to transfer back to my mother and dad's, because I was trying to do the best thing for me and for my sobriety.
Randy, is there anything I'm not asking you think Judge should know?
Other than, I asked on the fingerprint gun that my fingerprints were not on that gun. And, I was sitting in the driveway in a vehicle that was hers. They tried to say that I had a gun, sir, and I didn't. The individual he's saying testified was her father that really does not like me and hates me a whole heck of a lot. And,
Thank you, Randy.
Because he had.
You have any questions, Mr. Tom?
Just one, had you had that gun out in your possession and anybody in the neighborhood saw you with it?
No, sir.
I'm just kind of curious. The officer testified that the complaints he got matched the description of that gun. And it was a unique gun, wasn't it?
No, sir, because I've never seen the gun before, and the individual that he's saying testified against him.
You saw it that day, didn't you? Had a turquoise handle on a 9mm pistol. That's kind of unique, isn't it?
I don't deal with guns, sir. I've never owned a gun myself. I've been a convicted felon since 2000, Your Honor, and not been around guns, period.
Okay. You have anything else you want to ask your witness?
No, Your Honor.
You have any other witnesses you'd like to call?
No, Judge.
Okay, what's your argument?
Well, Judge, we're essentially, we've got a case within a case. As Mr. Meter stands here, he's presumed innocent under the law, under those charges in Edmonson County, which, Judge, are not resolved, have not been resolved by a rocket docket. Court net showing they're on for May 23rd of this year. And as Randy said, he intends on fighting those charges. So Judge, to impute guilt from a case that's not even been resolved, I know they're trying a constructive possession case there in Edmonson County, but Judge, I think it's constructive guilt, what the Commonwealth is attempting to do here. Judge, I would say let due process play out before we revoke a man for allegedly having a firearm.
All I can say, Judge, nothing good comes from something when you're outside your area of where you're supposed to be at. Whether you had permission or not, I don't know, but I'm like Officer Bray, he shouldn't have waited a month to go up there if he did have permission. And I've never, and you heard the officer testify, he said the complaints he got matched the description of the gun, so I'll leave it with the court.
Judge, I stand on the fact that case is still pending.
What do you want to do, Mr. Stocks? You will wait to see what happens to that case.
That's fine. If you want to, I know, and if you found innocent, if they sanctioned for being outside the jurisdiction.
Yeah. Okay, I'm gonna give you the benefit of the doubt at this juncture, Mr. Miller, as far as wait to see what happens to that case down there that's going on, and it's scheduled for when?
May 23rd.
Well, if that case gets dismissed on that date, I'll let Mr. Metter out here and that'll be his only sanction. I'll put him back on probation. Okay? Okay, thank you very much.
I have a question, Your Honor.
We need to ask your attorney that. He'll be up to see you there, so, okay? Daryl Platt. Daryl Platt.
He's coming.
Yeah, it's the Granger.
Commonwealth versus Daryl Platt, 24 CR 0015 for the purpose of arraignment. Mr. Platt, what's your year of birth?
1237.
You born in 1977, Platt?
Correct.
And the last four digits, social security number 8578.
Correct.
Okay, you have a right to remain silent here. Your attorney is present. The grand jury of Cumberland County has charged you with possession of methamphetamine and possession of drug deals. You acknowledge the identity of Mr. Platt, pursue the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserve all pre-trial motions.
Yes, Your Honor.
Mr. Platt will have a negotiation day on April 5th and the next court days on April the 25th. What's this bond situation?
Yes, Your Honor, I'm showing in this case, it's 25,000 and 10%. And then he has another 24F17 that's 1,200. Yeah, sure. Moderate age to reoffend, and a high 7 for FTO.
Okay, he's got those other charges. Want to get all those around. Hopefully, you can get this other information to counsel.
We can talk about them all, both of them together.
Evidently, Mr. Platt, you were indicted on something else that your attorney will tell you about it. Put it all up there on that negotiation. They should wrap these things up, okay? Commonwealth versus Johnny Riley. Combo versus Johnny Riley, 24 CR 0009. You Johnny Riley,
Yes, sir.
born in 1989.
Yes, sir.
Last four digits of your social security number are 9320. Is that correct? Your day for the purpose of arraignment, you have the right to remain silent. Your attorney's here. The grand jury of Cumberland County returned an indictment charging possession of a controlled substance of first degree methamphetamine. Counselor, do you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea of guilty, reserving all pre-trial motions?
Yes, Your Honor.
Okay, we schedule Mr. Riley for a negotiation day. here in Burkesville on April fifth, and court date's April 25th. What's Mr. Riley's bond situation?
It's $15,000 surety.
Mr. Riley, that's not very much surety. You ain't got nobody to make it for you?
Honest owner, I have no family and everything else, and I'm disabled, and I got disability and all that, and only job I got is doing odd jobs for my neighbors. And everything. And my mom and dad just passed away.
Okay, wait a second. What, how does he rank?
Yes, Your Honor, it's a low 2 to re-offend, and then a moderate 2 for FTAs.
Do you have FTAs in the past?
Be honest on it, if I get out here today, I will do everything.
Wait just a second, we're looking at it.
Okay.
Your Honor, showing that he has had one, but it is older than 2 years old. It was July the 7th of 21.
Okay. Where are you gonna live, Mr. Riley, if you get out?
With my cousin, Tyler Clary.
Where is that?
Pretty much, below the Spencer Street is over Spencer Street, like the next road over.
Here in Burkesville, right?
In town, pretty much, I'm living in town and everything else, not far from Judson.
What do you think about Lori's bonds?
I have no objection. He's gotta have, as a minimum.
Will your cousin sign a $1,500 surety?
I really got no numbers, so I can't call nobody. I love to get out here today, to be honest with you.
I'm sure you would. You and everybody else up there like it out there. I'm trying to get you out.
I really ain't got nobody sign me nothing because I call my Uncle Mark.
You had your cousin, you said. What's the address there?
I'll check the court.
You know the address? I really don't know either. I know.
You don't know your cousin's street address?
He's right up from Johnny Newby's, Amy Hills, who's dating my cousin. I really don't know, to be honest with you.
Does your cousin have a name?
Tyler Clary.
Tyler Clary.
Hill Street, he lives on Hill Street.
Hill Street, quote, misconceived.
South High Street. Is any of his family members, cousins here in the court today?
I've been in the room with him, Judge.
You what?
Judge, and just to add clarity to this is a case where there's 4 co-defendants. I think a couple of Rileys, so.
Is that supposed to prejudice me against him that there's 4 co-defendants and 2 of them are Rileys?
I didn't want a family member to stand up and be a co-defendant, Judge.
It's a shame lawyers can't sign bonds. I might try you on for size on this one. I'm gonna let this guy out on an ROR bond on his own recognizance, but when you get back down here, you go to your cousin's house over there. You stay in the house, don't get out of the house, but to work, church, or the doctor.
Thank you, Judge.
You can come down here and speak to your lawyer if he makes an appointment with you at the Justice Center. Okay? And not to use any alcohol, no drugs, not break anything, okay?
Promise.
Okay.
Thank
you. Matthew Riley. Matthew, are you kin to Johnny there?
Yeah, I hate my nephew.
Okay. Commonwealth versus Matthew Riley, 24 CI 0008. Mr. Riley, were you born in 1968?
There was.
last four digits, social security number 8553. Is that correct?
Yes, sir.
The grand jury Cumberland County charged you with possession of methamphetamine. You understand that charge?
Yes, sir.
Counselor, do you acknowledge the identity of Mr. Matthew Riley? Enter a received indictment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Formal reading. Schedule Mr. Riley for a negotiation on April 5th and here in court on April 25th. What's Mr. Riley's bond?
Let's have the others out here. Showing. Well, for some reason, they've shown us 50,000 property, but 50,000 property, cash, 50,000 property, Your Honor. That's a list, yes, is that something?
Paperwork showed 15,000 surety, Your Honor.
Well, it says 25,000 surety now.
No.
You don't have anybody make this bond for you, Mr. Riley?
I don't. My boss, Rachel Spears. Mr. Rachel Spears, the guy I'm working for, living at South 161. He's got his land tied up on an overseer. Someone's overseeing his estate because he's got prostate cancer right now. He's very sick.
You gotta talk about Etchell, is that who you said?
Yeah. Yes, Etchell.
Well, I'll accept Etchell on a surety, a $15,000 surety. Would that be all right with the Commonwealth? Is there any reason? Mr. Stockton?
Yes.
$15,000 surety with restrictions on it?
That's fine, yeah.
We'll let Etchell Spears sign a bond for you without putting property or anything up. Approve it, and then for 15,000, I want you, where are you gonna live at, Mr. Riley?
Same place, Mr. Spears' residence.
Okay, well, you stay at his residence and you leave there and go to a church, work, or the doctor, okay? Yeah. What?
Mr. Spears going to Burke's office.
So which one's the sheriff's speaking which one? Well, I'm approving it here. They say Mr. Spears has doubts as to whether he wants to sign a bond or not.
Okay.
So you might call him and see if he does. You can get out, or I'll let anybody else come in and sign the bond that the clerk will approve. Okay?
What about ROR for a couple of days so I can show him? He's very old and he's hard of hearing. You know what I'm saying? And I just need a couple of days and I'll produce an ROR or a surety signer, or I'll turn myself back in just like I did Sunday. I won't run from nothing.
Well, I'm gonna let you do that. I'll let you do an ROR for 48 hours, okay?
Thank you so much.
48 hours, and you get a $15,000 clerk approved surety. And
okay,
while you're out, you live at Mr. Spears' house, and you can get out and try to find you somebody to sign them, but don't get into anything else, okay?
I sure won't. Thank you, Mr. Williams.
Okay. Keith Smith for sentencing. Hello, Keith. This is 23 CR 0023 Commonwealth versus Keith Spears.
Smith.
Keith Smith, excuse me. Were you born in 1963?
Yes.
And last four digits social security number 8253.
Yes.
Okay, have you seen the pre-sentence investigation report done by probation and parole?
That's what we sent up there to you, Keith.
Have you reviewed it?
Yes.
Does it seem to be substantially correct?
Yes.
Mr. Cross, is any reason this gentleman should not be sentenced?
I know of no reason, Your Honor.
Okay. Upon a plea of guilty possession of handgun by a convicted felon, the defendant shall receive 5 years. Upon plea of guilty possession of controlled substance first degree shall receive 3 years. Upon a plea of guilty to operating motor vehicle under the influence, he should pay a fine of $300 and serve 7 days. All the sentences are run concurrently for a total of 5 years, serve 90 days, balance probation for 5 years. Now, Keith, when you entered these pleas, you understood that they were felony pleas and that you could be enhanced in the future. Is that correct? If you get any more felons, is that correct?
Yes. Yes,
You
sir.
also understood that the operating on a motor vehicle could be enhanced if you get another one of them. You understood that, correct?
Yes.
Okay. Well, I'll go ahead and impose that sentence. Was this 90 days supposed to be from today?
No, it wasn't. We were trying to figure its exact day.
It was 90 days total.
Yes.
Okay, so he's
He's got several days
time
in.
in.
No, he doesn't.
Mr. Gardner's trying to find that for us right now.
Mr. Cross was complaining, wanting to get him out to mow. He's gonna cut into his mowing season, so it's gonna be a little while yet.
It's time to mow. He works for
He's got
Junior
81
Smith.
days.
So he's almost there.
Yeah, wait just a second. What?
He's got
81 days.
days as of right now.
81 days. Well, I think he can hold out 9 more if you want to.
Okay, Keith will let you out in 9 days.
Okay.
9 days. So, okay.
All right. Thank you.
What's his court cost?
$890.
$890. You need to be paying it at $60 a month, starting 30 days from today. $60 a month. Okay? Down here.
Okay.
Circuit Clerk's office. Hope you stay straight, Keith.
I will. Got to.
See you. Bye. Tommy Thrasher.
He's right.
Yep. Not much.
Commonwealth versus Tommy Thrasher. 24 CR 0007. Has he filled out a form to see if he's eligible for a public defender?
No,
I don't think so. Yeah, I don't think so.
You what?
I think, yeah.
Yeah, Mr. Thrasher, I'm gonna appoint a public defender to take care of the arraignment here. Then we'll do a statement from you, see if you're eligible to get a public defender, okay?
Okay.
Okay. This is 24 CR 0007. Mr. Thrasher, you born in 1970.
Yes, sir, I was.
Last 4 digits, social security number 2769.
Yes, sir.
You're on arraignment. You have a right to remain silent. Grand jury of Cumberland County's returning indictment charging you possession of controlled substance in the first degree methamphetamine and possession of marijuana. You had that, Counselor, you acknowledge the identity of Mr. Thrasher, received indictment, wait formal reading and arraignment, and plead not guilty or serving now, please trial.
Yes, Your Honor.
Okay, I'll set a negotiation day for Mr. Thrasher on April the 5th, and the next court dates, April 25th, both days here at the courthouse at 9 a.m., the 5th and the 25th. What is Mr. Thrasher's bond?
Bond amount is 15,000 sureties.
Okay, Mr. Thrasher, your bond amount is $15,000 surety. That's a low bond. Do you have anybody that can come in and sign it?
No, sir, I sure don't. Trying, I have nobody.
Yeah. Where do you live, Mr. Thrasher?
Harry Lane, Marksville.
Cherry Lane?
Yes.
That's here right in town?
Yes, sir.
In one of those buildings where the old church was, or?
In one of those apartments down there. Louise Carey or whatever used to own or run them, you know?
Yeah. Yes.
And Judge, if it makes any difference, excuse me, Mr. Thrasher is a third of the 4 co-defendants in the Riley matter. Talk about.
What's his score?
It is actually, Your Honor, he is a low 0-0.
Okay, Mr. Thrasher, I'm gonna let you're a 0-0, which is good.
Good.
So I'm gonna set your bond at 0.
Thank you,
You
Judge.
said a ROR bond, but you need to, when you come down, you can sign it there to jail. Do you have somebody come get you?
Maybe, I'm not even sure about that.
Well, Thomas J's bringing a bunch up there, maybe you can catch her right on the way back.
Yes, sir, I was thinking that same thing.
Okay, well, if you sign a bond up there, we'll let you out. You stay at home, at your home there, at that apartment, except to go to church, work, the doctor. I guess you need to go, you go to the grocery store, do you? Or
Yes.
you go to the grocery store too, okay? Okay, we'll see you on the 5th and the 25th, okay?
Okay, thank you.
Yeah, okay, Shannon Walters. Shannon Walters. Shannon Walters.
Present, Your Honor.
Walters?
Yes, Your Honor, I am.
Okay, we're on 21 CR 0062 and 21 CR 00146. We're here. Mr. Walters, were you born in 1978?
Yes, Your Honor, I am.
Last 4 digits, social security number 8199. Is that correct?
8119. Your Honor.
19, okay.
Yes, Your Honor.
Okay. You're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Walters has a 6-year sentence on theft by unlawful taking on 21 CR 146 and a 3-year sentence on possession on 21 CR 62. And my understanding was that Mr. Walters absconded last year and then was picked up later, and we finally extradited him from Tennessee after he served out his sentence down there.
You want to stipulate?
No, Your Honor, there's extenuating circumstances in this.
Of course. You want to call your first
Yeah, I
witness?
call Officer Burton.
Officer Burton, you raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Proceed. Identify yourself and whom you're employed.
I work with the Department of Corrections, the Division of Probation and Parole, and currently supervise clients out of Adair County.
Okay.
Ms. Burton, were you supervising Mr. Walters out of Adair County when you supervised him?
He was probated on March the 31st and was on Officer Garner's caseload, and I accepted him on May 13th of 2022 and supervised him until he absconded.
Okay. What violations did he have and when did he abscond?
On October 6th of 2022, there was a positive drug test, an admission to marijuana. On October the 7th, there was a failure to make restitution. On October the 31st, Mr. Walters failed to report. On November the 18th of 2022, he absconded supervision and failed to report the change of address. And then on February the 7th, when he was picked up on that warrant, he had a new misdemeanor arrest.
February the 7th of 2023?
Yes, sorry. No,
Okay.
no, that would have been this year for the new misdemeanor arrest for the promoting contraband at the jail.
Okay. So do you know, he absconded in November of 2022 from your caseload, is that right?
That is correct.
And the records I have from probation and parole show that he was arrested in Dixon County, Tennessee in May of 2023, May 18th?
That is correct.
Okay. And I guess he spent some time in Tennessee jail, is that correct, before he came back to Kentucky, or do you know?
That is correct.
Okay. When did you next have contact with me?
After Mr. Walters' absconder warrants was issued out of Cumberland County in November of 2022, the next date of contact that I had for Mr. Walters was the day after he was arrested in Dixon County. And he was calling me from the jail to advise that he was picked up and serving time on his Tennessee probation matter, so that way he could come back to Kentucky and be back before the court.
You know when he came back to Kentucky? When he was extradited?
To my knowledge, it was January of 2024 or February. I don't
Okay.
have the date in front of me.
And did he stay in jail during that time, or was he out?
He stayed incarcerated.
Okay, and we're just now getting to the motion, I guess, here in March.
That is correct.
Okay. Now, did he have permission to be in Tennessee?
He did not.
Okay, was he arrested in Tennessee on a warrant out of this court, or did he have other charges or probation in Tennessee?
From my knowledge, Your Honor, he had previously told me that he had warrants that was non-extraditable out of Tennessee for other probation matters that was never taken care of.
Okay, and so I guess when he absconded from you, logic dictates he went to Tennessee and got arrested in Dixon County.
To my knowledge, he advised me when he was picked up on the 19th of May that he turned himself in. So I don't have any clue about how that proceeded.
But to your knowledge, you didn't have any contact with him after November through May when he turned himself in Tennessee.
That is correct.
I have nothing further, Your Honor.
So officer, I want to stay here. So officer, I want to start at something you mentioned and quickly get rid of that. You talked about a misdemeanor violation or misdemeanor charges on February 7th.
Yes, that has since been dismissed and I forwarded a SSR to the courts yesterday.
Okay, just wanted to get that as part of the record. So those contraband charges dismissed.
That is correct.
Because Mr. Walters had a prescription for the medicine he took in with him, right?
I don't have any knowledge of that case other than the charge and the dismissal.
And then as you discussed with the Commonwealth, from when Mr. Walters made it into Kentucky, all the way back to what was it, May of 2023, he's been locked up in Tennessee, right?
From May of 2023 forward till today, he has been incarcerated either in the state of Tennessee or Kentucky.
And in fact, as you testified, Mr. Walters called you to say, hey, I'm in Tennessee jail, right?
Mr. Walters has called me on several occasions, including some other information.
Let's talk about that other information. He's actually been instrumental in helping you all apprehend someone, right?
He disclosed the location of where his wife was staying at in the state of Kentucky while he was incarcerated in the state of Tennessee.
In jail, and you know, Alan, he did his right. He could on the call. I know why, but they wouldn't get threatened. Okay. And that. Go ahead and bring it in. I just want to caution you. No, no, I'm just.
So again, officer, Mr. Walters is being cooperative with you, correct?
That is correct.
What time period?
After he was called.
You know, that I'll speak.
You said there was a recommendation to the SSC?
Yes. He was recommended to, give me just a second here to look at my paperwork. He was supposed to complete outpatient treatment with interest and also do MRT classes that was recommended by the SSC.
Thank you, officer. Those are all the questions I have.
Oh, you're right. This officer be released.
Yes, Your Honor.
You may be excused. Thank you for appearing.
Thank you, Your Honor.
You have anything else?
No.
You have anything?
Should we stay on the proof and again ask particularly
Okay,
that
wait a
last
second. You have no other witnesses?
No.
He has no other witness. Now it's closed. Now, you'd like to say anything?
Judge, we would ask that that last recommendation, the social service commission be adopted by the court, allow this man to get some rehabilitation. I'm not going to sit here and make excuses for the time from November to May. But if the court looks at it, he took accountability for his actions, turned himself in Tennessee, remained in contact with probation and parole the entirety of the time he was in Tennessee.
Well, that's not entirely correct. He maintained contact with probation and parole in Tennessee after he turned himself in. He took a 6-month sabbatical somewhere, and we don't know because he wouldn't contact probation and parole. I don't know how you can reward conduct like that.
Yeah, I just can't allow people just come and go when they want to, check themselves in here or there, and not do this, not keep anybody informed. In this case, just gone to another state that he had no right to be in, and then turn himself in down there after several months. So, you know, well, I'm gonna have to revoke Mr. Walters. Yes, maybe get this behind him, okay? Cody
Judge.
Willis. Cody Willis.
Good afternoon, Judge. Ryan Roby here on behalf of Mr. Willis.
Hello. Commonwealth versus Cody Willis, 23 CR 0040. We have a pretrial conference set, but we also have a arraignment on a new charge. So, Mr. Willis, you have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging possession of controlled substance in first degree assault. Now, Counselor, I have this new indictment. Have you received a copy of it?
I have not received a copy, Judge. If Mr. Pennington from the office could pick it up today, I did talk with the Commonwealth and knew that the charge was coming and discussed it with my client, Judge.
So you acknowledge the identity client, receive the indictment by the office, wait formal reading arraignment, enter plea not guilty or serving all pretrial motions.
Yes, Your Honor.
We'll go to a conference, a negotiation conference on the 5th at 9 a.m. here in Burkesville. The next court appearance is the 25th at 9
That will
a.m.
work for us.
Okay, thank you.
Thank you, Judge.
Dare County, do you have anybody else for us?
Nope, that's it.
Thank you for your cooperation. You may be excused.
We have 2 cases before the hearing. We have Sheila Burchett, who's here for the arraignment. She wasn't here earlier. And we have Brian Muse for sentencing. Mr. Carrott's on Zoom, and then we have the hearing on Mr. Come out of the thing.
You what? Yeah.
Yeah, that was Kyle. She wouldn't hear much.
Where's the lady that was late?
Mr. Burchett, she's out here now.
She's supposed to be invested.
Okay.
Where is she on the docket? Out of custody. Angela Branham. Sheila Burchett. Take Miss Burchett into custody.
Your Honor, could we address the court regarding Ms. Burchett?
Once we get her in custody, you can take her into custody. Okay, now bring her up here. And Mr. Cross, you represent her?
Yes, Your Honor.
Just stand behind there. What do we got going on here?
Your Honor, Ms. Burchett.
Are you Angela Burchett?
Sheila Burchett.
Sheila Burchett, rather. Born in 1960. Last 4 digits, social security number 2230. Okay, now, why weren't you here this morning?
I thought it was Thursday. And I got the reminder and I just read Thursday.
Okay, I'm gonna accept that. Because this is an unusual day for us to have it. And you did come on in. I'm gonna arraign you on this. I'll withdraw the bench warrant.
Thank you, Your Honor.
Where is the file for Ms. Burchett? You send me that. We're gonna go down and get this, and that, right back up. You have a right to remain silent. You are represented by counsel. The grand jury of Cumberland County is returning the indictment, Ms. Burchett, charged you with trafficking in controlled substance, possession of controlled substance in first degree, possession of drug paraphernalia, operating motor vehicle under the influence, speeding, failure to use a seatbelt. You understand those charges? Counselor, you acknowledge the identity of your client received indictment, wait formal reading and arraignment of plea not guilty, reserved all pre-trial motion.
Yes, Your Honor.
Okay, she will have a negotiation day on April the 5th at 9 a.m. The next court appearance is April 25th at 9 a.m. Both been our conditions of your bond. Okay? Thank you very much. There's your reciprocal discovery order that you should be, y'all have discovery for him.
Yeah.
Then we have Angela Branham. Commonwealth versus Angela Branham, 23 CR 0053. This is a hearing for a hardship license, is that right? What's your story?
I am in drug court
Yeah.
and I've had to go back to drug court to Adonta to work. And my mother has cancer and my dad is.
She doing well in drug court?
I haven't had any complaints yet.
Okay.
We
well,
won't
what I
meet
want
till
you
the
to do
28th.
is, I will give you a limited hardship license and I want you to put the locations that you have to go.
Okay, I turned the,
She's got her.
Yeah.
Her records work and her classes.
Okay.
She's put the days and times that she needs. to
Okay.
do.
Now, are you living with your parents? taking
yes,
care of-
yes.
Well, do you need to go to the grocery and things like that for them?
Well, I mean, if I could,
Well, I'm asking you if you need to.
okay, yes.
You can if I tell you you can, but you gotta tell them you need to.
Yes,
Okay,
yeah, that
well,
would
I
help a
mean,
lot.
how old are your parents?
My dad's 71, my mom's 67.
And they're both sick, are they?
Well, mom has cancer, dad's, yeah, very frail.
Can either one of them drive to go to the grocery or anything?
Dad can.
Well,
Mom's taking treatment, she's not going.
well,
Bad,
send him when you can, but I also put on there that you go to the grocery on occasion if it's necessary to take care of your parents.
Okay, thank you
I'll
so much,
sign it.
Judge.
I'll sign it.
Thank you.
Okay. Continue to do well, okay? Okay, who else do we have here? Number 10, Brian Muse for sentencing. Brian Muse. Mr. Garrett's on the TV there, you see him? Okay. Yeah.
He was like this case and that hearing Mr. Huntley's gonna handle that and they've called the ambulance for my dad, so I'm gonna leave.
Go ahead. Everything's okay. Mr. Huntley, you want to come around and handle this? This is Commonwealth versus Brian Muse, 23 CR 0037. You're here for sentencing, Mr. Muse. Your attorney's present electronically. Have you had an opportunity, Mr. Muse, to go over the pre-sentence investigation report to probation parole?
Yes, sir.
Is it correct?
Yes, sir.
Okay, is there any reason why this gentleman should not be sentenced, counselor?
No, Your Honor.
Okay, upon a plea of guilty to possession of controlled substance first degree, he received 3 years, probation 5 years. Probation to be supervised, he shall receive credit for 55 days. Pay a fine of 200 and what's the court cost?
440, that's what's the fine.
Okay, total of 440 plus tow bill of 175 and $500 for $675 for towing and storage to the sheriff's department on the Chevy. When that's paid, it shall be released. So it's $675 to the sheriff's department And what's the court cost?
440.
$440. So you make a payment of $100 a month on the fine and court costs starting 30 days from today. And you get your car back when you pay the $675.
Yeah, right.
Okay. Now you'll need to meet with the probation parole officer. There he'll set you up. Hope things turn out a little bit better for you. Okay. Okay, who else do we have here? What else do we have on the what? Tim Alexander.
Come on. That's the rest of you.
I didn't see this on the docket. I guess we continued for hearing last. What is the number?
His 23 CR 30 now.
23 CR 00039. Okay, you did file a motion in this case, Mr. Poindexter, to dismiss based upon the self-defense.
Yes, Your Honor.
What's the argument the Commonwealth has about this?
Well, Your Honor, that's the first question I have is what's the nature of the hearing that we are to have here today? Because I'm noticing a courtroom full of people out here and I'm assuming that many of them are to be witnesses in this case.
Well, they might just be interested citizens.
And that could be true also, but that would be my first inquiry.
Well, I want to know what you have to say about the motion first, and we'll decide what kind of hearing we necessitate. Okay.
Well, the motion is based on an affidavit of Mr. Alexander that was dated a week before this motion was filed and over a year after the incident occurred. That in itself tells me that that is not in the spirit of this chapter 503 and of the Rogers case, because that case was, and that chapter was designed to let people who had a quality defense bring it up, even before they were charged or before they had to go, that they were charged and had to go to district court for a preliminary hearing, or before they were indicted. We had a warrant issued establishing some degree of probable cause. We had a preliminary hearing, if there was one, establishing probable cause to submit it to the grand jury. You had an indictment by the grand jury. And now, as I understand the law, we are here today to determine whether the Commonwealth has probable cause to take this matter to trial. So I say that his motion is late, very late. And secondly, I submit to the court because I don't know what's going on here today. This is not a trial for the court to find facts relating to this case. I'm sure there are going to be witnesses on each side. It's not the court's place to determine the credibility of the Commonwealth's witnesses or the defense's witnesses.
Yeah.
That's going to be an issue for the jury.
You know, Mr. Poindexter, what's your position on it? Have you ever brought one of these at this stage of proceeding before?
I have not, Your Honor.
I've never seen one either, but laws change. I just don't really understand how the court can have a hearing to determine the validity of a self-defense charge. And y'all need to hold it down over me, okay? Because you can key in the microphone. I don't see how the court can have a hearing on a self-defense charge after it's been through district and circuit court and a grand jury and have a hearing here. That would be a fact determination, and self-defense is what it is. It's a defense, and it has been bolstered by the legislature somewhat. But do you have any case law where court has at this stage of proceeding had one and dismissed a case?
Your Honor, I simply have the case law of the Rogers versus Commonwealth that states that it's obvious that the defendant should be able to invoke KRS 503.085 sub 1 at the earliest stage of the proceeding, but then it goes on to say
the burden to establish probable cause that the defendant's use of force was not lawful is on the Commonwealth, at page 755. So I believe it can be brought up anytime up to the point of trial. And so, we're willing to do that. We had the hearing set originally, I think it was last week or week before. And we had witnesses that we were going to subpoena to that, but then it got canceled. So I wasn't sure if the court would hear this on a motion day or set another hearing date.
Judge, I can see that the burden is on the Commonwealth to establish probable cause, if that hasn't already been done. And
probable cause of what?
Probable cause
that there wasn't self-defense.
That the force used was illegal.
Well, if it was self-defense, it was legal force.
That's true. I concede that the burden is on us, but it's not the burden on us to go through a fact-finding trial here today. And
well,
I'm not
saying we're going to do anything today as far as testimony, but one of the reasons that I'm willing to hear this is I think the law was poorly conceived and poorly written. And here's it's the burden is on the Commonwealth to prove that the force was lawful or was not unlawful.
I think that's correct under that case.
Okay, now that goes beyond just probable cause.
Actually, the case of Taylor versus Commonwealth said that probable cause is reasonable grounds for belief supported by less than prima facie evidence, but more than mere suspicion.
Okay, well, that's probable cause definition before or after this statute?
It was probable cause definition after the Rogers case.
Was it about this statute?
Yes, it was. And this case concludes that once the Commonwealth meets its probable cause burden under the provisions of KR 503, etc., this inquiry is finished in this case.
Well, how can you meet that without having some
evidence? I have the victim, an eyewitness, an officer that proved that the victim fled, but I'm not prepared to listen to 10 or 15 defense witnesses here today because I don't think this is the
I don't think the defense witnesses can be used to refute what you say. I think you are going to give some testimony that overcomes this probable cause that it was not lawful.
That's correct.
And once you get to that point, if the sworn testimony is sufficient, then testimony to refute that wouldn't appear to be appropriate.
I would think it would be rebuttable to show that a person who testified on behalf of the prosecution was not telling the truth. And be able to show that to the court.
No more than you would have a witness in the grand jury to rebut the testimony to.
I don't know. This is it's gummed up deal is what it is, statute. These things sound good when they're voting for them and everything, but when you try to implement them, if I found, so you're saying that I listen to the testimony of the officers and then the people that refute that, and if I believe that there is probable cause to believe that there's not probable cause to believe that it was well done, that I can dismiss the case?
Well,
can I dismiss this case?
You can dismiss this case based on testimony, yes, sir. That's what this
and then he could never be held. It would be dismissed with prejudice?
I believe so. Yes, sir.
It's hard for me to believe.
And as far as a rebuttal witness, Your Honor, what I'm talking about is that if the alleged victim in the case gets up here and testifies as to facts as to why he was there, and we have other witnesses that could say that's not true and that he was there for this other reason, which was unlawful, I think we've got the right to put those witnesses on for you to hear that.
That would save a lot of time, Judge. That way you wouldn't have to bring a jury in here for trials. Commonwealth's entitled to a jury just as well as the defense is entitled to a jury.
I don't know the answer. So So,
I'm prepared to put on the evidence, Judge, of the defendant, an eyewitness, the officer that will testify that the defendant fled at the scene.
well, I'll tell you what I'm gonna do. I'm gonna let all the testimony in. That'll be a good discovery process for you. You'll know what the testimony will probably be at the trial. It won't prejudice the Commonwealth any, and then I'll determine whether I can use that evidence in my determination. Okay? How many witnesses did you have, Mr. Poindexter?
5, Your Honor.
That's my question, Judge.
What? What?
I just don't think that's proper at this point.
Well, I'm gonna listen to testimony, and then if I determine after reading what y'all have had to say about this or hearing that it's not proper, I won't consider it.
The Rogers case held that you could make a motion for an immunity termination to be made upon the then existing evidence, not the evidence that the defense has been able to manufacture or accumulate a year after.
The then existing evidence at the time of the motion. What it's talking about, right? And it says that the motion should take place early.
With the idea that the concept was to prevent all the work being done up to the trial and then coming in and making a motion for immunity right before or even during the trial.
I don't know that. You know, that sounds right. What you're saying sounds right to me. But I don't know that. So I'm gonna hear the testimony and then I'll make a determination as to whether I need to use it to make a decision or if I disregard it. Either way, it'll be in the record.
Yes, sir.
That way.
All right, that would preserve everything for appeal. Maybe we would make some law.
That's what I'm doing, you know.
That very well could be, Judge.
I don't know. Okay, well, you call your witnesses out loud here.
There weren't subpoenaed to be here today, Your Honor.
Oh, I thought you had them here.
No.
Mr. Huntley thought they were here. Well, let's schedule. Well, next Monday and Tuesday are gonna be an interesting day. Are y'all too busy that day on various things?
I'm ready today, Your Honor.
Well, he doesn't have his witnesses here.
But I'm saying if I present evidence today.
I'm gonna have him. Let him
All
have
right,
his
then I
witnesses.
suggest that we do it whenever the court pleases.
Let's do it on Monday, because we're not starting these other things until 1 o'clock.
Your Honor, I've got depositions in the federal case on Monday.
Well, you don't have time to do this.
No, sir, not on Monday.
I do, Judge.
You have a deposition on Tuesday?
On Tuesday, I've got court in Pickett Criminal Court and Monroe District Court. But we don't have a trial date set now, so if you need to set it 2 or 3 weeks out, that's fine.
Is this the only reason we don't have a trial date, this motion, or what?
I would think so, Judge.
Well, and we had a trial date, but it was canceled.
Basically, what this does is to give.
Understand what it does. And I don't know whether it can do that. It doesn't seem logical that all that happened that way, but we're gonna go through it. We'll find out what it does.
But I don't think it's right for him to be able to prosecute
Whether
all
it's right-
of the Commonwealth's witnesses.
Whether it's right or wrong.
All right, Judge.
Might
I
be
agree
the
with
law.
that.
I don't decide right or wrong.
I'm ready, Judge.
I know you are. Raring to go.
I wouldn't exactly put it that way, but
Well, let's see here.
I'm ready to go today.
Well, he's not.
Oh, it's not my fault.
Well, it wasn't on the docket. You know, it was inadvertently left off the docket. I didn't know, right?
It just wasn't on for a hearing. It was on for the regular motion day.
What does it say? What does the agreed order say?
Sort of probably first scheduled for March 18th, shall be continued, and virtual conference shall be scheduled for March 19th, so change the trial date.
So just here for a pretrial conference, continuing trial. Let's pick a date here.
Our witnesses have been here all day, but
Me too.
If you kind of remember, we had this issue in Monroe Circuit Court several years ago, but it was done even before the indictment.
I know that. I'm just gonna have to decide where they can do it now.
Well, I don't have the answer to that, other than it's not right.
And if
And
if I had the answer, I'd enter an order right now. I don't know. Okay.
Judge, I'll be available about any time.
What about on April the 10th?
That. I've got Cookville Journal Sessions and Cumberland District.
Well, you don't have time to do
But
this case.
I can do it the afternoon.
Judge,
We have a trial.
Do what?
The Tucker trial is scheduled to last 2 days.
Yeah, I had it on the 9th. I didn't have it on the 10th. Okay.
Yeah. I can do the 11th or 12th.
I have a rule day on the 11th.
Okay.
Now, in the Taylor case, Your Honor, the lower court held that there was probable cause. Then they proceeded to trial, and then on the appeal of the case, that issue was included in the appeal. And the appellate court ruled, after reviewing all the evidence, that the lower court was correct in allowing it to go to trial.
I hope I'm found that way too. I'll make the right decision.
It's certainly a unique statute.
I have a hard time finding it today.
Judge, I can be here any day of the court.
No, I'm having, I appreciate that. But Megan, do we have anything on next Wednesday? 27th?
No.
How about Wednesday, the 27th?
In the afternoon, Your Honor. We've got district court that morning.
Well, you know, how many cases you have in district court that day?
I have Clinton District at 9. And then one Cumberland District, a Dare District, and then back here for a juvenile Cumberland District.
I think a half a day was good, Judge, if that was one.
Well, I'm trying to figure out how to do it. What time can you be here on the 27th?
I should be back here by 11:30.
11:30?
Yes, sir.
Started at noon. 27th.
Judge, that's the Holy Week service, is it?
Pardon?
Isn't that the week of Holy Week services?
I can't understand what you're saying.
Holy Week.
Holy Week.
Yeah, that's right. Started at 1:15.
Yes, sir.
Judge, I'd like to recognize witnesses that I have here today.
Such a lot. What's it? See, I can't see the calendar. Okay, who are your witnesses?
If I could have James Haywood, Davy Griselius, Officer Craig Gross.
Move your client back to your table.
And Mr. Mike Turner.
They come around, please. Okay, y'all spread out across here. Each one of you raise your right hand, you swear or affirm. If you don't take oaths, you can do the affirmation. Each one of you swear or affirm that you will be here at 1 o'clock or 1:30 on March 27th to testify in the Alexander case under penalty of a $250 fine. Each one of you do that? Okay, thank you. Reverend, do you participate in this Holy Week stuff here? Do you?
I used to go over, but I'm not participating.
Well, we'll get finished. That's the reason we're doing it 1:30 instead of. Okay, thank y'all very much. Okay, is there anything else? On the docket?
For me,
Perhaps you'd like to enter into conversation about the rule against perpetuities.
well, I got a B in course, Judge, and was so proud of that because it was the third highest grade in the class.
Well, That concludes the business of the circuit court. We're in recess until 1.
And I was absolutely positive. I told my classmates when I left, if I ever failed a test in life, that was it.
Judge, we're not done. We're not done.
Okay, what do we have left?
There's a show cause docket and a diversion completion docket.
Show cause and then what? Let's do diversion completion. Is anybody here for the show cause docket? Okay, where is that? The diversion completion docket first. Commonwealth versus Dakota Anderson. Is there any objection to that? On behalf of the Commonwealth? On behalf of the Commonwealth, is there any objection to Dakota Anderson completion of diversion docket?
No, Your Honor.
Okay, thank you. Show cause docket. Commonwealth versus Jason Bailey.
She's supposed to be paying $30 a month. We've been putting court notice on 2/8.
Do what?
We've been in court notice on 2/8 and we've not heard anything from him.
Okay, we'll issue a show cause. He can issue a warrant. He can pay $240 and purge himself, paying $240. Alfred Cornelius, $1,160. How is it? Alfred Cornelius, how much he paid?
We had a $50 payment this morning.
You're supposed to be paying $100 a month.
I didn't know I set up on no payments yet. I paid $100 last month and nobody said, this is the first time I've been back to court over since I got out. It's been out for a month.
Okay, well, I'm gonna let you go today.
Thank you,
Pay
sir.
$100 a month. First payment would be due 15 days from today and 30 days every set it up like that, okay?
Yes, sir. Thank
Give
you.
you a chance to get on your feet. Okay?
Thank you.
Okay. Aiden Fields.
You paid $50 this morning.
Do what?
You made a $50 payment this morning.
Is that 190 includes the 50?
No, it's what we have 180.
You just owe 140, you pay $50 a month. So you get that 140 off, okay? You're on your way rejoicing, okay? Tamara McCoy.
Call this morning, made a $40 payment.
Okay, tell her to make, communicate with her and tell her she needs to pay.
Ordered her to pay $25. She pays $25.
How far behind is she?
For $659.
Do what?
She owes $659.
Well, how's her payments been coming?
She's been making, I'm just gonna put her on the dog there.
Okay, that's fine. Okay, we'll be back in 10 minutes for the child support doc.
Don't forget to your phone.
Do what? Sure. child support docket. Long versus Long.
Judge, Mr. Long asking for a review date on the 19th of September.
September 19th, okay. Cooper versus Cooper.
Judge, a wage withholding has been established. We're asking this be reviewed June 27th, please.
Wage assignment.
Yes, sir.
Presidius versus Alexander.
Judge, Mr. Alexander's case is on today for an order of arrest. If you recall, the last time we were here, February 25th, Mr. Alexander was here and we gave him until yesterday to purge himself of contempt by paying $500.
Did he do that?
He has not, nor has he come to my office to make arrangements. He's
Have
actually,
him-
he's
have
paid
him
$0.
arrested, issue a bench warrant.
Judge. Judge, I have an affidavit on that, or I can take testimony if the court desires it, but it's,
I remember it from last
yeah,
time.
it was already placed on the record last time before.
Yeah.
Thank you, Judge.
Is that it?
So that's all I have.
Okay. You know, the docket's not scheduled to start for another 8 minutes, but if parties are here, we can go ahead and advance. Stevenson versus Tri-County, are all the parties here?
I'm not sure, Judge. I'm here for Tri-County and do believe my clients would like to attending. I don't see it here.
Okay, well, we'll wait for 5 minutes then. Come, you come around and put something ready.
I'm not going to go on the record.
I know. Stevenson versus Tri-County Electric, 20 CI 00038. There's a motion for summary judgment. Could you find that? Yeah, I read it last night. Did you have any motion up, David, kind, or are you just defending?
I'm just defending, Your Honor.
Yeah. Okay, now you're, Franklin, is that right?
No, sir, I'm Anthony Johnson. Franklin is no longer with the representing firm, so I've assumed this case. He filed the initial motion, I filed the reply.
I'm familiar with relevant facts. You had a couple of free theories where you said that Tri-County Electric has a prescriptive use on a plaintiff's property based on its presence of its overhead power lines. That was the first thing.
Yes.
How can a prescriptive use mature from a permissive use?
Well, I would argue that it originated with the prescriptive use.
I'm just asking you a question. I'm not asking what you argue. I mean, I'm just asking for information. Could a prescriptive use evolve from a permissive use?
Potentially, yes.
I think that's true, especially if they went beyond what the permission was and established some sort of. What's your position on that, Mr.
I think if there came a point in which there was a clear adverse use of the property, then, for example, on a roadway, somebody puts up a gate, probably changes that position from a permissive to adverse, or could.
Well, I'm interested in all these, this situation, so. Let's say the facts, I'm not asking you to accept this fact situation.
Sure.
But let's say that Tri-County Electric came out there and Dr. Stevenson, the elder, told them they could run a line across a certain piece of property over there, over to a trailer. You said something about a trailer over there.
There is a trailer that's not on our property.
I know where the trailer is.
Okay.
It's over on what used to be the Alexander property up there, Mr.
It's on that little short street that doesn't appear to have a name.
Yeah, well, there's a big house there, Mr. Reed's house, or I guess Mr. Reed's house was there years ago when I was a child. There was a huge mansion there. And there's a trailer there now, but let's say somebody allowed you to run a wire across there. And once do you do written easements for those things? Is there a written easement on this thing originally?
There's not originally, no. And if I understand what you're asking is proposing an alternative route.
No, I'm not. I'm just asking things to clear up what the situation is there.
Yeah, no.
Does that power line, does it go over to one property owner over there, or does it says something in your pleadings that goes up, provides power going up Baker Street?
Correct. It's
Okay,
not just the singular property, it's a network of properties.
Do you believe that to be true?
Well, the line in question runs from a pole on the, what I call the mobile home or trailer property,
Yeah.
to another pole
The York
on the
property.
Judd property.
And the Judd property is up above the Stevenson property.
Yes, Your Honor. It's there in the curve on King Street, or just off of King Street.
and it runs across the Stevenson property.
Our evidence is it does not, Judge.
That's the reason I was asking you that.
Our evidence, Dr. King has testified, if you look at the photographs, looks pretty clear it does not run across the King's property. The Stevenson property.
So you think it goes from the Judd property over to the York property without crossing the Stevenson property?
Yeah, I think it does.
You don't agree with that?
I don't, Your Honor. The power lines, they hung above the trees, which are in dispute. If they're saying the power lines aren't on the property, then neither would the trees.
Well, and then of course you talk about this secondary easement, which makes sense. You know, people have a secondary easement. What do you say about the secondary?
If they establish a primary easement, the case law which they cite and rely on says they have a secondary easement only to the extent that it is necessary.
Right.
And that it is a question of fact as to whether or not their actions then are necessary. That's the, I forget the name of the case, but it's the one that's cited by
The farmers.
the Farmers case. Back in the Farmers case, the court reversed it because there was a primary easement and apparently not contested in that case, but still reversed it for a trial on damages for the jury to determine whether they had exceeded what was necessary.
You say the Tri-County Electric only cleared the vegetation that was necessary. Of course, that's a fact question, like you said. And the subject walnut trees interfered with the reasonable and natural use of the transmission lines, which is a fact question. There is no affirmative evidence to show the existence of material facts to defeat the Tri-County Electric's motion for summary judgment. What do you say?
Well, there are facts. Number one, that's whether the line crosses our property. Number two, there's actually two different lines, as I understand their argument in question. There's the one that runs from the Tri-County property to the Judd property. There, basically where that curve is on King Street? And, but according to their evidence, Dr. Stevenson, the elderly Dr. Stevenson, paid them to move the line, and they reached an agreement where the line would go. Back in 2010 area, and actually paid to have that line moved.
Did they move it?
And they moved it. So that encompasses a few of the trees.
Well, I read it a few times and I didn't notice any. Did you have any pictures attached to your? There was somebody that had some plottings or something. Referred to some plotting lines. What do you call those lines?
The plottings do not show our boundary lines, Judge.
Yeah, I didn't see that in there.
And of course, they would have the burden of establishing where their lines are in relationship to our boundary line.
You have anything else?
Well, Your Honor, there was two diagrams that were certified and
I didn't see those
presented in the file.
Let's see if you can find them. My staff lawyer makes me copies of things that I take with me. And I didn't see those in there. I saw.
So Judge, those diagrams are not to scale, they're not surveyed, they're
Not saying
just,
they are, I just.
just kind of useful for kind of showing the general
Do
area.
you have a survey?
I do not. I did point out in in my brief, where the lines, our lines can be found, because it's in the center of the branch. And there's a fence there that presumably would be the back boundary. Although it's not been surveyed, and I haven't, because I don't have the burden of.
Did you make a demand for any particular amount of money?
I have not, Judge. Number one, the complaint doesn't allow you to do that. Rules of procedure. I believe that applies.
You could have made one before the complaint was filed, you know.
The word I have gotten from Tri-County all along is we're not paying a dime. I think it's two people standing on principles.
Well, I'm familiar with the property. I grew up on Baker Street. You know, I never understand why all the Walnut Creek plants so close together, each other behind them anyway, you'll have it. I don't see how they have very much value. I mean, they're about that far apart, weren't they? I haven't looked back there.
They're fairly close, Judge.
Your Honor, to the point about the property lines, I don't think it's necessarily relevant to decide these issues, because the easement would supersede any property lines, whether it's Stevenson's
Well,
or the
it would
neighbor.
prove whether or not you crossed any of the Stevenson property or not, or whether, as you alluded to the other day, if the trees aren't on Dr. Stevenson's property, they're on somebody else, and then I guess they could claim that they had adverse claim for that property beyond their property lines by virtue of having planted and cared for trees for 20 years or something like that. I don't know. I have this, your membership corporation sitting here.
I think the adverse aspect of it is, it's come into play, I think, more recently, because the trees have grown. It wasn't necessarily an issue when they were sprouts and they weren't interfering with the lines, but up until now.
But not a problem until they are.
Exactly.
So that line, that particular line does more than go over to that trailer over there, something.
The power lines or the tree
Yeah.
lines?
That you cleared the pathway through the walnut trees.
Correct. It powers more than just the trailer. It provides energy to multiple properties nearby and down the street.
I can't really tell much about that. I on purpose have not gone out there when this thing has started, because I didn't want anything, but I probably would like to make a trip out there and look at the property. What have you got there, Daryl?
I followed this as exhibit 13 to our brief, but I have a better and larger copy I'll share with council of the Google photograph of the property, and if I might show the fort, there's a hole right in here.
Oh, yes. This was before the cut.
Judge, I do not know.
That'll be before the cut.
Yeah, presumably. Uh, The line in question is from this pole right in this curve
Let him see it here too.
over to,
Well, let him see. Let's put it on the Elmo, and you can mark it on the Elmo, and that way
okay,
everybody here can see what you're.
all right. Excellent idea.
You gentlemen can, it's gonna be on that screen behind you there, the Tri-County.
Another thing on the property line, Your Honor, is we did actually have GPS data and
30-foot easement, 15 feet on the side of either line that's there. That's pretty reasonable, isn't it?
Well, Judge, that's fine on those cases where they have a written easement. When they're claiming a prescriptive easement, according to the farmer case, you first have to have the prescriptive easement, which they don't have because they don't have a line running across our property. Among other reasons. Secondly, under the farmer case, they only have what a jury finds is reasonable and necessary. And they want to say, well, we've got to come down on our side of the cut tree so they can get to the line. Well, no. They've got a wide open field on the judge side of the property where their line is located. And they essentially have admitted that these trees could have been trimmed rather than cut down. Because they said we could have enrolled them in a program where we pay to have them trimmed. But that's under their regulations. That doesn't apply to us. Because our property is not served by Tri-County. We have no electricity on our property. This line is not on our property. So in the farmer case, the prescriptive easement was established or not contested. And what was contested was whether they could go in and clean under it. And the court held that to the extent necessary, they could do so or they have a prescriptive easement. But you can't run a line 10 foot on somebody else's property and say, well, I've got a prescriptive easement over on your property.
That's what they are saying.
That's what they're saying.
Your Honor, I disagree with the assertion that this is not on Stevenson's property, and this was in the original motion. This is GPS back on the, but basically what we have here is.
You can't go back. Yes.
Thank you, Judge.
Thank you.
Judge, could I file this larger exhibit forward?
What kind of exhibit is it?
The one that.
This one here?
Yes.
It can be, I don't, for illustrative purposes, I don't think you've laid a foundation to get it in the other way. You know what I mean? It's just, it is what it is. I get that. So you can file it just for illustrative purposes.
Thank you, Your Honor.
Okay, thank y'all very much. There's one other thing I'd like to, where was the line that he had moved? It was moved when you paid him to move it.
It was along King Street. Went from the RACC property to the Judd property, and at one time crossed our property. And
he had it moved.
Dr. King Senior, even though he didn't own the property at the time.
Dr.
Stevenson, I'm sorry, paid to have that line moved. It had already been deeded to the grandchildren. But in any event, I guess.
So they, after the line was moved, they still cut trees on both sides of it?
Well, it's actually on one side of it, but yes, they cut trees after he had paid to have it moved.
Okay. Okay, thank you very much.
All right, thank you.
Morgan versus Myers. Morgan versus Myers. What do you have here?
Judge, we're here.
Do you have any diagrams or anything you want to put up?
I do not. I'm a little less flashy than the previous case. We're here on a motion for a default divorce.
Okay.
Service
proper?
Yes, Judge. We served the petition for divorce via sheriff's service back in September.
On the respondent?
I'm sorry.
On the respondent?
Yes, sir. He appeared here on the October rule day.
Yeah.
We entered into a temporary time sharing agreement. You requested for him to get counsel or to correspond with my office regarding the divorce.
Was there any personal property or real property?
No, Judge.
Anything? So it just has to, you just asked him for divorce alone and not any action on timeshare or anything?
No, we're not asking for any sort of action to take place other than to finalize the divorce.
Okay, we just submit it, we'll sign it.
Thank you, Judge.
What are you gonna do about the timeshare and stuff? Bring it up later? Do you reference it in the decree?
It's the temporary time sharing is referenced in the decree. If he wants to change it at a later date, we'll let him bring that action before the court.
Okay.
Thank you.
Okay, just submit it. Webb versus Webb.
I'm assuming this is the motion hour, not the EPO DVO, or which judge?
I didn't know there were two of them. We'll find out. I gotta explain it to me here.
So Your Honor, there was an EPO filed by Mrs. Webb in district court, and I represented Mr. Webb on that. And then this divorce action was filed.
And it brings it up here with it.
Yes.
Love it. What have you got?
Your Honor, we have filed a motion for temporary custody, child support, and an order scheduling for final hearing. And there's some issues regarding the marital home where my client has an investment of approximately $40,000.
40 or 20?
Around 40.
40,000.
And we are asking that.
How long have they been married?
I think around 7 years.
Okay, Judge, if I may, with regards to the divorce, and I'll say it again, I spoke to Ms. White about this. I'll be representing Mr. Webb in the divorce action. He was served with this on March 1st. He has yet to file an answer. I know he's here before the court, but I would say I'm here, but I'm not filed an answer. So I would say that Ms. White's
parents. You said words without reserving.
I would say,
Welcome to the
Judge,
case, Mr. Penny. Welcome to the case.
and Judge, I'm fine with that, but, you know, given,
I'm not gonna do anything drastic, so today, I mean, we're just gonna, what is the timeshare is in place with the EPO?
There is time sharing, which Mr. Webb has.
With the EPO?
Yes,
Okay.
8 hours on Saturday. We did temporarily work that out. It is supervised by his mom.
Yeah. But until we get deeper in, is that working okay?
I think that's fine. You know, obviously, Mr. Webb, a lot more time, but I'm ready where we're
Probably
at.
get, might get more time. So what are you asking today in particular?
Today,
In the
we're
divorce case.
In regard to custody, we're asking for temporary sole custody and to leave the time sharing as is for now.
Well, I'm not gonna give anybody temporary sole custody today, but we'll leave the time sharing as is. I'm not gonna make any permanent decision about that since they haven't filed an answer and there's no proof been taken. And there's no personal property to divide,
There's, she has a marital interest
but that's real property.
and there is personal property as well.
But I
that
was
she has
asking about personal property.
Yes, and
They hadn't
then
divided their personal property. She living in a marital residence and he had to leave because of the EPO.
no, she left out of just fear and.
Well, I don't
all
want
that.
you to testify.
Yeah, she left
She
the marital
left.
home and she's having to stay with her parents at this time and she has no residence.
Okay. And so the marital property, is there, in the EPO, was there a restriction on him being able to dispose of personal property in the marital estate?
I don't think that was addressed. It was just, the personal protection.
Okay,
There are some items that she would like to get, that belong to her parents and her mother.
how long have you
grandmother.
been in this case?
Less than 30 days, Judge.
Well, but so is there a lot of personal property, or do you think it would be easily divided, personal property?
There's significant personal property. Some of the things though, like I said, there's a zero-turn mower that her grandmother purchased. That's her grandmother's, that she paid about 4,000.
Okay, I don't want to get into detail. I just asked if there was a lot. Now, who, the deed to the property, whose name is the deed?
The deed was to,
Don't be gesturing or something like that.
the deed was to Mr. Webb, but after they married, he owed between $20,000 and $25,000. My client had some non-marital funds, which can be traced that she paid off the mortgage. I think it was almost $21,000 of it.
How long before they were married did your client buy this property?
Yeah, that's 2014.
When were you married? What
We
year?
married 2016 or 16.
So you had a couple years before you were married. And what do you think the law is on that? When somebody owns a piece of property, they get married, somebody moves into the property, and they marital assets pay the mortgage.
That's traceable to things which make the property have an interest, which is marital, based on, I guess you would have to go through the Brandenburg formula if it was sold. My client at this point is just basically asked for the return of her funds. There's been blacktop placed, mortgage paid, various improvements to the home, basically totally remodeled.
Would
And
you
Judge,
pay?
that's gonna require some tracing.
I'm not gonna do it today.
I'm
I'm just asking what their theory is.
Yeah, we will be able to provide documentation of all that. We have it. So,
Of course, the problem that you have on mortgages, when you pay for mortgages, the initial years are all interest. And it doesn't pay down the principal.
she paid a lump sum payment of, I want to say it's $20,998.
Did she have that money or did she borrow that money?
No, she had that money. She had had a wreck prior to the marriage and that was her settlement.
She
And we have
did
the,
the down payment or
She
at
paid the
least
final
paid
payoff.
toward the mortgage.
the final payoff in full.
You think you could talk to your client to see how much he's willing to give her toward buying her out of the house?
I can speak with him, Judge.
I think it's always helpful.
We attempted to do that earlier, but
Well,
yeah, we would be
things
happy.
change when they come into court.
We
you
would be
know? I
happy
mean,
to do that.
These people don't like each other. I know you can relate to that. I know I can. At a certain point, Mr. Poindexter can relate to it, and I don't know Pennington well enough to know whether he can relate to it. I hope he never has to.
I'm married once, Judge, hopefully prayers.
Yeah, well.
I understand, I do a little bit of this, I'm not.
Hopefully, you know, but the thing about it is you've experienced with people that have a
Absolutely.
tendency, and sometimes if the lawyers get together and work down through the numbers of it, show them the futility of their situation, they can come to terms on that. So why don't you draw your theory of what the property's worth to her, what she gets, and then you simultaneously draw your theory up of what he owes her, if anything. Y'all can exchange that information. So,
Unfortunately, I don't have enough information at this point. Mr. Webb is still getting the value of
I'm
what.
not talking about today.
Oh, okay.
I have a summary. I'll probably have
Well, I
it.
mean,
Absolutely,
talking
you're
about maybe within 20 days.
Yes,
Y'all can
certainly.
exchange information about what you claim that she would get under the Brandenburg theory or whatever, and what you think she's entitled to. And if the numbers are close, you might have something to work on. Then she needs to write down what personal property she's interested in. And if there is something that she claims is not personal property, like the lawnmower that her grandmother or whoever bought, he's probably gonna say it was given to both of them. You know, that's the way it usually goes. But he needs to make a realistic list of what he'd be willing to say is personal property, and anything as he's identifies as non-marital property, marital or non-marital property. That gets us a start to go with those schedules to each other. And if we can get those schedules done, we'll just be down to the custody situation now. So that's what we're gonna leave in place, what's there now, until I hear this EPO. So now we're gonna flip over to the EPO, and that's where you're involved, Mr. Poindexter, is that right?
Yes, sir.
Judge, if I could say one thing about the scheduling, would it be possible that we could go ahead and get with the commissioner, get a date set out for like a couple
I'm
months?
planning on settling this without y'all going to the commission.
I just like a backup plan.
Well, I don't know if you schedule it to commission, you're talking about a 6-month backup plan. What's been happening recently, am I right or wrong?
I don't know how backed up he is at this point.
Well, I don't know. I'm talking about how quickly the reports get out.
Oh, yeah, the reports, exactly.
That's what I have to see, and then y'all file exceptions to them, and there we go. So a good settlement is worth better than a long wait, you know. Now, you want to bifurcate, you want to go ahead and get them divorced?
I would love to do that if the court would entertain that.
Y'all don't have any objection to that?
Okay.
Okay, well, we go ahead and bifurcate, go ahead and get them divorced, so they go on their single lives. And then y'all will, in 20 days, y'all exchange the information about the value of the house and list on division of the personal property. Now, where do you work? Do you work? Okay, do you have a retirement 401k or anything there? Do you work? Where do you work?
I work at the nurse town.
Okay, do you have a 401k or any, no retirement plan whatsoever? Well, you'll need to give them the information on that there, okay? Okay, let's do the EPO. Can you hand me this EPO thing?
In your honor, Mrs. White and I had spoken, if the court would allow us, we're in agreement to continue it for 6 months to see if they can work out something within the divorce.
What I had, Your Honor, if I may, I had talked to Mr. Poindexter that maybe in that 6 months, his client might be willing to attend a parenting and anger management.
Let me read this thing again.
Oh,
I'll flip through it. Yes, sir. Can you raise your right hand? Swear that the testimony in your affidavit was true and correct. Is that correct? Okay, you want to raise your right hand? Okay, you swear that the testimony you're about to give is truth, whole truth, and nothing but the truth. Okay, you want to inquire of him? Ms. White will inquire first.
Sir, sentence.
You want us to sit down or stand?
It's not necessary if Mr. Poindexter should let him stand on the inside.
Let me find my documents. I've got it all together.
Well, first, are you disputing the allegations that are in the affidavit? If you don't, we can get by there.
You disagree with some allegations? Yes.
Okay, well, go ahead.
I would.
Your Honor, so I'm assuming that you won't let us enter into an agreement.
I want to hear what it says and then.
Please state your name.
I've already heard hers. I don't need to hear her. She said what she said here was true.
Okay, I thought you asked.
So I want you to inquire of him. He said.
Oh, okay.
He put him behind the stand there and then you stand out and ask him questions. You asked him questions, Ms. White.
Mr. Webb, you've read the content of the protective order, petition that Ms. Webb filed, if you know.
Yes.
And do you agree that on January 2nd, that there was an altercation in the home from which you later pled to an assault charge on Ms. Webb?
Yes.
So you did enter a plea in district court that you assaulted Ms. Webb?
In the 4th degree, yes.
Do what?
The.
Assault on 4th degree. Nobody ever told me that before.
And on this occasion, did you, start arguing with her when she returned home from work?
No, she actually started arguing before she came home from work.
And you continued to ask her to come to the bedroom in which you pushed her down the bed?
Absolutely not. She, bumped me with her head like a headbutt in the face, so my reaction was to push, and then that's when the altercation took place, where she was punching and, hit me instead of.
And later you held her down and put your hands around her throat and strangled her, did you not?
Absolutely not.
And then you proceeded to put your hand over her mouth.
Absolutely not.
Let me ask you a question. You pled guilty to assault.
Yes.
What did you do what were the factual situations?
The push.
Let me finish my question.
Sorry.
What are my factual situations that led to you pleading guilty to assault? What do you say you did?
They offered me, not to have the felony or whatever, which I did not do or whatever. My counsel said that it would probably be better to take the plea bargain, so not to have the felony.
Okay.
You proceeded, Mr. Webb, not to hold Ms. Webb down on the couch while you had your hands around her face and neck, causing a bruise on her neck.
Absolutely not.
And isn't it true that you began a verbal altercation with her daughter, her 12-year-old, telling her you hated her?
No, her 12-year-old daughter, after she was, screaming for no reason for her to come in there to involve the kids, I said, just don't involve the kids or whatever. As soon as I opened the door or whatever, Haley hits me in the head a few times with
Who's Haley?
My stepdaughter or the older daughter.
Yeah.
She hit me in the head a few times. I didn't know what she had or whatever, so I just took her phone away from me. She and Emily were talking about how they hated me and I was useless. I don't remember saying that I hated her at all.
Y'all have one child together?
Yes, sir.
One other question. Isn't it true that you followed her to the vehicle and in front of the children stated that you was going to kill yourself and that it was Emily's fault?
Absolutely not. What happened was Harper wouldn't let me go. I'm her father. She's extremely attached to me. She did not want to go with them or whatever. I was bringing her out to the truck or whatever. She still wouldn't let go of me. That's the only reason they were held up at all from leaving.
But my question is, isn't it true that you made that comment in front of her?
Absolutely not.
You have any questions you'd like to?
Just to clarify, the assault that you pled to, the facts of that is the pushing.
Yes.
Okay, well, that's all I have.
Okay, well, I'll reserve my decision on this EPO and see what sort of agreed mutual restraining order or something you can have in a divorce case. And then if you can't agree on something, I'll make my decision on this. If you can't. Now, does this EPO in any way affect your work where you're working?
When I first got the job, I just had to write a letter of recommendation saying that, you know, the situation was one time thing, would not happen again, and I'd grown from said situation.
Yeah. Okay, well, y'all see what you can work out and see if your client is satisfied with the level of protection that restraining order gives her. Okay? And if she's not, then I have the testimony here in the affidavit that I can make a decision on whether I'll do domestic violence work. Okay?
Sir. And Judge, if I may just briefly, I represent Mr. Brinker in district court. I can say that it is 2 years, no violent contact.
You don't need to be vouching for anybody. That's testimony. That's testimony, you know.
I think it's just like, what the sentence was, Judge, and it's no violent contact this way.
Well, that'd be good for all the time. I'd say you'd agree to that right now, wouldn't you, not to have any violent contact with her? I'll agree to that. I won't have any violent contact with her, so. Not much of a restriction. Okay, well, thank y'all very much for your patience. I know that other thing ran a little long, so thank you very much.
Thank you.
Okay, do we have a confidential docket today?